Hello, check. Hello. Hello, check. Hello.
May I, my lord, crave my lords?
September. Yes.
May I crave my lords kind indulgence, my lord. My lord, your lordship may kindly recall on Tuesday, my lord, the DLF batch of matters I had mentioned it to.
Parted before this.
That's right. That's right. But my lord, yesterday it was mentioned without notice to any of us.
If you are in difficulty, we'll keep it on another day. You
Only-
can't come in June.
Only thing, my lord, the 6 withdrawal applications, which are the IAs, those are a 1-minute matter, my lord. And only your lordship is, my lord, saying.
The first week of June.
Unfortunately, my lord, unfortunately, no, my lord. Otherwise, my lord, I'm sorry. If I had known this would be fixed, I would not have fixed the program.
The gentleman who appeared in person on.
He's here, he's online. He may not mentioned without, after your lordship had discharged the board, he mentions without.
He's coming from outstation. He has to remain present in court all day. No matter if it is not called on.
I appreciate that. Would
To
you?
him. So an old man, we.
No, I completely am mindful of that. I am only requesting your lordship these 6 withdrawal applications, which my lord will then give them their money and my lord they can go home. If those could be fixed on Monday or Tuesday.
That buyers who have agreed to withdrawal of the.
6.
Who are they represented by?
My learned friend is here.
You're representing.
That's right.
That gentleman is not required.
No, not at all. Not at all. Otherwise, the case history is showing 14 July. Let the matter be there on 14 July on reopening, my lord, for the final hearing.
These are IAs seeking withdrawal.
Just the IAs, the 6 IAs seeking withdrawal.
Gentleman there. You say
Mr. R.K. Sharma, he's online. He can get a fixed date, 14 July, any time.
Not joined.
Your lordship may give him any time, my lord.
Connected. Mr. Sharma? Can you hear us, Mr. Sharma?
Your Lordship, even I am representing some of the appellants who have not settled with DLF and willing to argue. Your Lordship, first week of June is difficulty for us. 14 July is.
Bring those 6 withdrawal applications only tomorrow. Those who want to argue, they will argue on 14th.
Deeply grateful to my lords.
Grateful.
my lord. I'll give the learned courtmaster the entire list, my lord.
Right.
Very grateful to my lords, my lord. That's right. The 6 withdrawals so that they can go home, my lord.
But it's there's one withdrawal application which is lying in defect. The defects are not being taken by the registry because it was on board for 3 days. My lords may say that may be.
Subject to
record-
curing of defect, all
I'm obliged.
petitions for withdrawal.
Really grateful to my lords, my lord.
Obliged.
Grateful.
Yes, call on the list.
May I please, my lords? My lords, the petitioner has been convicted under section 147 for the offence under section 307 and 304 with a rigorous imprisonment of 10 years, my lords. My lords, the allegation against him is not.
Please come to para 4.
Please, my lords. Please,
Para 4 of the judgment.
please, my lords. My lords, before that,
The role of the appellant number. Just hear us for a while, thereafter we'll hear you.
sorry, my lords.
Appellant number 1
Please, my lords.
is attributed the role of assaulting the deceased with a sword,
Please, my lords.
right?
Please, my lords.
The postmortem report says
Please, my lords.
there are lacerated wounds
Please, my lords.
caused by hard and blunt substance.
Please, my lords.
So appellant number 1
Please, my lords.
says that if I have used a sword to assault him, where is the incised wound,
Please, my lords.
right?
Please, my lords.
It's a different matter that the court did not grant bail to even appellant number 1,
Please, my
although he stands on a better footing than you.
Please, my lords.
Now, you are attributed the role. Come to page 4. Chandan Kumar assaulted the informant by iron rod along with 3 other persons.
Please, my lords.
Now, what is the nature of wound found by the postmortem doctor?
My lords, may
Hard and
I,
blunt substance.
my lords, may I submit
So
the
therefore,
allegation?
you have been convicted. You have lost the presumption of innocence. You have spent only 1 year, 2 months out of 10 years.
My,
Go and pursue your appeal.
my
before
lords,
the-
the allegation against the petitioner is not assaulting the deceased, my lords. It is against the informant, the complainant, my lords, which is, my lords may kindly see page 78, para 15.
Yes.
Because, my lords, the allegation, same one injury and 3 person has been alleged, my lords, that they have attacked. My lords may come para 15, page 78, my lords. Because that's the complainant who has, that assault is on the complainant, not on the deceased, my lords. Page 78, my lords, para 15, my lords. Please, my lords. Witness number 7, Dr. Sukhjit Kumar has been examined on behalf of the learned additional public prosecutor, who is his examination in chief and has stated on date so and so was posted as medical officer. On date day and so, I examined Ravindra. My lord, he's the informant, age about 35, son of so and so, so and so. One injury, lacerated wound on right side of scalp 3 inch. My lords, that is the injury. And my lords may see in the FIR. See, three persons. He has been alleged with 3 persons, my lords.
Yes.
This attack, and my lords, the similar, the person who has been similarly, the allegation of the similar nature, my lord.
Sorry, madam.
My lords, my lords may see, my lords, he is already undergone 1 years and 8 months, and the allegation is against the informant. There is no support, there is no discussion, my lords. My
Thank
lords, may
Thank you. Be grateful. Next.
May please, Your Honor. First, this is an application grant of.
How many witnesses are proposed to be examined?
Only 1 or 2 more witnesses. Eyewitness has been examined, my lord.
We are asking you how many are to be examined. You are saying eyewitness has been examined. We know
2 more.
eyewitness is PW2.
Yes.
How many more are to be examined?
2 more witnesses, my lord.
Huh?
2 more witnesses.
Because the SLP is silent, our lead instruction is a fresh matter, but the eyewitness.
So only 2 witnesses are required to be examined?
Yes.
Huh?
Yes.
In a murder case, we will release you when only 2 witnesses are required to
The
be examined.
eyewitness is not examined as per the SLP. Jagdish Yadav is the person who was with the.
No, he says
Yes.
that 2 have been examined.
Yes.
Depositions are on record. It is not appearing because the charge sheet perhaps is not on record.
Record matter, no detail.
So we don't know how many witnesses. He says another 2.
Yes.
Let us accept another 2. Why should we grant you bail in a murder case?
Your Honor, the 3 accused persons, there are 4 accused, 3 have been granted bail. The person who has not surrendered has
Sorry.
been given anticipatory.
Dismissed.
Your Honor, grant me the liberty to approach the trial court in that case.
Then you withdraw. We'll just simply say dismissed as withdrawn.
I'm grateful.
Dismissed as.
Grateful, my lord. Would my lord permit me to give my appearance, please?
Yes.
Grateful.
Yes, my lord. 5 years, almost 6 years is in.
This is also 302. How many witnesses
only
are
one
proposed?
Only one witness, lordship, complainant. In 23rd
How-
March,
You have not annexed the charge sheet. Have you?
lordship, no.
Then how do we ascertain? You don't say anything. You know, this is the
Lordship.
deficiency in the pleadings.
is a-
You are seeking bail, right? You must show what is the progress of trial. Nothing, silent.
Lordship.
Not even a whisper as to how many witnesses are proposed.
Only one lordship.
In a murder trial, only one.
Yes, lordship. Now,
So as from the charge sheet, only one is to be examined.
one examined. One examined.
One is, say that.
Yes.
How many else are required to be examined?
56.
56. Very well.
He
And all witnesses of fact be examined. Trial court is encouraged to expedite the trial. Dismissed.
Lordship, consider lordship 6 years, almost 6 years. And FIR, 2 FIRs filed in same date.
Yes. Trial court
2
will
FIRs,
expedite the
stand
trial. We have given that direction.
lordship, one person against
On such
20.
a half-baked petition, don't expect any
Lordship,
order
I will
from
file.
us.
Lordship,
Right?
Lordship, within 1 week, I will
Nothing is
file.
there.
Lordship.
What is your role? We don't get to know.
Lordship,
Because the charge sheet is not
Lordship,
on record.
within 1 week, Lordship, I will file Lordship. Lordship, consider 6 years is almost 6 years in jail. 1 week.
Liberty to file additional documents.
Lordship,
Released in August.
Lordship, he has 11 antecedents and he has not
Oh, this is
disclosed.
11 antecedents. Right. I noted.
Lordship, may see
11.
para 9.
Sorry. 11
Lordship,
antecedents.
FIR
How to
has,
explain that?
there are 2 FIRs filed by the prosecution, Lordship.
Hmm.
One is
9.
20 kilometers distance between 2 FIRs, Lordship.
Wait.
And one in other FIR, Lordship, this 4 minutes.
Sorry. Recall that order. Dismissed.
Lordship.
Item 4, my lord. My lord, 3 years in jail.
Please, my lord.
Petitioner.
Investigation is complete and charge sheet is laid.
So this is the NDPS.
NDPS, my lord.
We don't treat it as an as an ordinary IPC offense.
Correct, my lords. There,
4 bail petitions in 1 year.
my lord, there is something.
What is the change in circumstances,
There
sir?
is something erroneous. All 4 bail petitions have been dismissed on the ground that twin conditions have not been satisfied. But twin conditions will not be applicable because there is no commercial quantity involved.
Why 24 kgs of ganja?
No, my lords may kindly have the seizure memo at page 15, my lords.
Page 15. There are
Serial-
3 people. You say that there are 3 people.
Page 15, my lords, serial number 5. What is record from me is only 8 kgs, my lord. Page 15, serial number 5, my lords may kindly see. What is record from me is only 8 kgs.
There are 3 persons from whom
3
24 has
persons,
been.
From me, only 8 kgs was recovered. Even this 8 kgs, my lord, we are disputing because the forensic report says leaves and
Where
leaves.
is the charge sheet?
Not charge sheet are not filed. I will file it, my lords. My lords may kindly.
Nobody files the charge sheet. You disable us from looking into
I
the
will
charge
file
sheet
it.
and find out what is the role attributed to you, and then you expect
I
that
apologize.
discretionary
I will file
jurisdiction
it.
to be exercised.
My lords may kindly grant me some time, my lords. I will file it.
Anyway, we'll 4 bails in 1 year. You don't. Why didn't you raise this point before the court? You're
My
not
lords, it
raising
was
this
raised.
point
It
before.
was raised, my lords. It is recorded in the impugned order. My lords may kindly have page 2, my lords. Of the impugned order, I have at para 3, my lords may kindly see. Third line, the further contention of the petition is that the petitioner along with other accused were found in possession of 24 kgs ganja, but each of the accused were carrying only 8 kgs of ganja. Hence, section 37 of NDPS is withheld as each person were containing 8 kgs of ganja, which is an intermediate quantity, but it was not considered, my lords. All 4 petitions are dismissed solely on this ground that twin conditions were not satisfied. Lords, even otherwise,
Show us the first order.
Lords, the very first order. My lords may kindly have it at page 32, my lords. The relevant para is at page 33, para 4, my lords. Last 3 lines. Therefore, the petition.
This argument was not raised before the court on the first occasion. It's only 24 kgs of ganja. Where is the second order?
Lords, it is at page 35, my lords.
Yes, page 35. Where is this point raised?
Lords, para 37 is the fourth para, my lords may kindly see at page 36.
Yes.
Even otherwise, the prosecution case is that each one of them were possessing 8 kgs of ganja, which means intermediate quantity, and therefore rigor of possessing commercial quantity will not arise.
So it was in 1 trolley bag.
No, my lords. Three bags from my
In
trolley.
a trolley bag. In a trolley bag.
Yes, my lord.
In a trolley bag. What is the stage of the trial?
My lord, charges have not been framed.
My lords, I'm appearing on advance notice, my lords, I'm seeking
That
time.
will be framed 1 year. Obviously, within 1 year from date of commencement of trial, if the trial is not concluded, liberty to pay for bail. Dismissed.
Grateful.
Next.
This is the case of gross miscarriage of justice. 20 years I have been waiting, lordships, for my compensation.
Yes.
Grateful, lordships.
May it please go. Lord, after winning the first round, I am now Milord worse off. Milord, now let me tell Lordship, Milord, in a nutshell. I have made, Milord, a small note for your Lordship's consideration because the issue started, Milord, long way. Give a copy to the court. Give copies, please. Milord, it's completely, Milord, completely illegal what the High Court has done.
The rules be applicable.
Yes, that's the only question. Now, my lord, if your lordship just have a look at this. See, my lord, see the chart first.
This one.
Just see the chart. So, my lord, left side is, my lord, the mining leases. Right side is the forest clearance. My lords get that? This is the chart I gave to the High Court also, my lord. So, it's on record. So, first lease, my lord, 54 to 73, 20 years. Second renewal, my lord, 74 to 93, 20 years. Now, my lord, on the third renewal, this is, my lord, 1/1/2014. Just make a note, my lord.
Yes, 1/1/14.
So, my lord, your lordship will find on the right side, the forest clearances, my lord, I have got at all times, but they are different, my lord. They are not, my lord, on identical dates. My lord sees that? That's the problem, my lord, which the government addressed. What happened was, my lord, on 1/1/2014, I didn't get a renewal on 1/1 on that day. So what the government said was, on 29 January, it is not here, on 29 January, my lord, the government said that your FC, though valid, is lapsed because there is no ML from 1/1/14. This ML from 1/1/14 actually came in September 14, my lord, with effect from 1/1. So I said, my lord, that my FC, my lord, your communication that the FC is invalid is wrong. I came to the Supreme Court directly, my lord, because these cases were pending here. This court, my lord, suspended the order of the central government, saying that, my lord, there is a gap and you can't mine. That was suspended, my lord, for 10 years. Then the Supreme Court said, you better go and file a writ petition. So I went and filed a writ petition. The writ petition was allowed, saying, my lord, saying that when you got it in September, it will date back to January, and therefore, my lord, there will be deemed to be a seamless continuance, and there is no hiatus. So it continues. Now, my lord, there are two circulars to answer Justice Datta's question. Now, your lordship may leave this. Now, kindly turn to the next page. In 2006, the Supreme Court said you pay NPV, my lord, I paid 107 crores. Now, 29/1/24, what was I was saying, my lord, they issued, my lord, a communication saying that you don't have it from 1/1, therefore your FC lapses. The Supreme Court, my lord, stayed the operation of that order. Mining continued, and on September 14, it was renewed from 1/1/14 till, my lord, December 33, which is 7 years hence. No problem. Now, because, my lord, the dates were, my lord, not matching across India and people were running from here to there, the government came out with the guidelines, my lord, in 2015. Allow me to read that, my lord. Respondent issued guidelines, that is government, central government, which stipulate that the validity of an FC shall be deemed to be extended. You don't need to apply. For a period coterminous with the mining lease, subject to payment of NPV. There was no requirement, therefore, to apply. So, my lord, by virtue of this, and by virtue of the High Court judgment, and with my seamless, my lord, continuance, in 2015, my FC, if your lordship would come back on this, my lord, my FC, my lord, would be deemed to be coterminous. At the end now, the last FC is, my lord, till December 26th of this year. By virtue of 2015 guideline, my lord, subject to payment of NPV, which I have paid as per Supreme Court order, my FC will be valid till December 33, my lord, by a deeming fiction. This deeming fiction, my lord, was in a problem because of, my lord, the 29, my lord, this 29/1/24. My lord sees that. Because of 29/1/24, I did not get the benefit of 2015 in 2015. But, my lord, when it was relegated to the High Court in 2025 has allowed my writ. Justice Anjaria's bench, my lord, as the lordship was the Chief Justice. That has been allowed. Now, my lord, on the same page, my lord, your lordship will find last, same page. The division bench by judgment dated so and so set aside the communication and held that the mining leases will continue seamlessly. Liberty was granted to approach the authority, my lord, for execution. This is ministerial because I have FC, which is deeming, my lord, from 2026, it will go till 33. But I need forest lease, which is ministerial, my lord. So I went to the department. And the department now says that you pay 138 crores and, my lord, buy 900 acres of land and give it to us.
So why do you say that 23 will not be applicable?
Correct. My lord, your lordship will straight away see 23, the document. My lord will see, my lord, in volume 2, page 438, my lord. That's a short point. 438. No, sorry. No, 438. 438. I am not showing you 2015, my lord. 2015 has been held in my favor anyway. Kindly turn to 438, my lord. Volume 2, my lord, page 438. These are, my lord, consolidated guidelines and rules. My lords, this is dated 29th December 23. Much after, my lord, I had got, my lord, my things. My lord will see the last line. All the provisions enshrined in last line, my lord, enshrined in the guidelines will be applicable from 1/12/23 is prospective. Can't apply to my case, my lord. Second, my lord, the actual guideline then starts, my lord. Your lordship may be pleased to turn to 446. These are statutory. 29th November 23. First, see, my lord, 1-2. They will come into force on 1/12/23, and to cement it, my lord, if your lordship goes to the top, in exercise of powers conferred by so and so, and in supersession of the rules, except as regards things done or omitted to be done. For me, my lord, 2015 would have applied, but for the snag which I faced, which snag was removed by the High Court. Now, my lord, the High Court says, why should not this apply to you? It can't apply to me, my lord. I fought a battle from 2014 till 2025 in the Supreme Court and the High Court. I succeeded. Once I succeeded, there has to be, my lord, seamless extension of the FC till as long as the mining lease is alive. Now 7 years are left, my lord. I don't need to pay anything. I had to pay NPV. My lord may see the 2015 guidelines also. My lord, a few pages earlier at page 400. A few pages earlier, if you lordship. Page 400. This would have applied to me in 15, but for the snag created in 2014, which snag was removed with retrospective effect by the High Court. And the High Court judgment is final. My lord, justice 400, my lord.
Mining lease in 1954. Right. Forest Conservation Act was not there.
Correct.
Forest Conservation Act came into force from 1980. Certain obligations accrued, which you had to discharge. Similarly, 2023 guidelines impose certain new obligations.
They are only for.
Why will you say
because
that it will not
because
apply?
they are only for those, my lord, who are applying in 23. I didn't have to apply.
Why?
Because I am covered. I was showing you.
This is for protection of environment, Mr.
But I have done whatever was required. I don't have to, my lord, just have a look. See, kindly see page 400, my lord. I was showing you 2015. Just turn to 400 for a second, my lord. 400. This applies to me admittedly. The High Court in the first round held this applies. And it is admitted, my lord. I show you, my lord, one by one. I haven't shown you the High Court judgment as yet. My lord will see 1/4/15. Your lordship will find this is the subject. See, my lord, paragraph 3. After careful examination, I am directed to say that in the case of existing mining leases, which are mine, specified in 8A1 as inserted by the amendment, amendment will not extend the validity. Period of approval, validity of approval, according to section 2, shall be extended and shall be deemed to have been extended up to a period co-terminus with the lease in accordance, my lord, subject to the condition that I will pay the NPV. I paid the NPV, my lord, as per the Supreme Court's order in 2012. And this, my lord, this would have taken my FC valid.
Does this 1st April 2015
yes
not stand superseded by the notification?
No, my lord. Come back to 438. Very important question.
446 is issued in supersession of the Forest Conservation.
Correct. But just have a look, my lord. Just have a look
Just
again.
a government order, executive instruction. This is just an executive instruction. How can it survive?
How can How can a prospective document apply to somebody, my lord?
No, this is.
See the saving also. Let's see the saving. 446 top, my lord.
Tell us.
Yeah.
Then this logic would have applied even in 1980. That why are you insisting that I should require a forest license to be obtained?
No, my lord.
Because I have got the mining lease from 1954.
True, but my lord, there was no concept of forest till the Act came, my lord. Till the Act.
Sorry, Mr. Rodhi, we are not inclined.
My lord, your lordship may have a look at the judgment of the High Court, my lord.
You've seen.
My lord, I have succeeded and ultimately landed back in the same problem, my lord.
We feel 2023 has been rightly held to be applicable to you. Next,
My lord, I wanted to show you the exception at 446 again. It says, my lord, except as regards all things done or omitted before the supersession.
Thank you.
Yes.
Yes, who appears? Appearance is willing to be referred to mediation?
Yes, Milord. I am for the husband, Milord, respondent 2, Milord. I'm seeking a passover, Milord. No.
Willing to explore mediation?
No issue. We'll do that.
No issues?
Yes,
Well,
Milord, because one child is with him and one child with me, Milord. A senior mediator may be appointed because there are issues between the parties, Milord.
senior mediator.
Great. Would my lords give us a date during this vacation period so we can utilize this? Yes.
Matter will be returnable in August.
Where will it?
Either in May or in June. The
I'm so obliged.
direction will be given.
Grateful.
Please, my lords, I'm appearing for the petitioner wife.
Yes.
My lords, the service has been complete on 30th of March 2026, but nobody has turned up
No
on the other
appearance.
side.
Allowed.
Obliged.
Plus 12 appear for the petitioner wife.
requesting for a Passover.
Lordship, may I just request one thing? They have filed a counter, there are certain averment which are being made. I need to rejoinder their Lordship. Permit me a week's time. I file my rejoinder to that effect, Your Lordship.
But in the meanwhile,
In mediation has failed, Your Lordship. We have explored the possibility. Yes, before this honorable court has mediation center has failed, Your Lordship.
Land Council appearing for the petitioner seeks and is granted 2 weeks' time to file rejoinder affidavit. Released in August. Stay to continue.
Please, madam.
Right.
Please, madam.
Mediation, Milord. There are multiple proceedings pending, so let that mediation happen for all the.
Which one?
Item 10, Milord.
Item 10.
So there are 3 other cases, so it may not be limited to only this case, Milord.
Mediation may not be limited to the dispute raised involved in the transfer petition, and the senior mediator to be nominated may
My lord,
attempt to bring about a mediated settlement in respect of all other pending disputes.
I'm so good.
my lords, in item 11, can I have the order dusty? Please?
Item?
11. Can I have the order dusty, please? Transfer petition has been allowed.
So it has been allowed. Why dusty? The records have to be transferred, then you,
No issues.
not in this man.
Lordships,
Yes, 13.
item number 13, I will request for the mediation, Your Lordships.
Who appears for the petitioner?
Your Lordship, I'm seeking a Passover in this.
Willing to
Sure.
explore mediation?
Yes, Your Lordship.
Very
Will much obliged.
Yes. Next, 14 adjourned as per letter.
May I request for mediation in that matter? 14 serial number, Lordship.
Item 14. Who is for the other side? Respondent? Respondent has asked for
We have
adjournment.
no objection, Milords. No objection, Milords. Milords, let the matter be
The
referred to
online
Milords, in
mediation,
the
both
meanwhile.
parties are from outside.
Although a letter has been
Deeply obliged.
circulated on behalf of the respondent seeking adjournment, at the time of call, Land Council appearing for both parties submit that they are not averse to exploring a mediated settlement. Yes. Bring it up in August.
Lordship,
Stay to continue. Stay if you need to continue. Yes, 15.
Lordship, the diverse petition filed by the respondent is allowed by the learned trial court. Therefore, I am withdrawing. this
Infractuous.
petition.
Submit that the transfer petition has been rendered infractuous, disposed of as such.
Much obliged.
Next.
May it please, Lordship. This is my
16.
application for anticipatory bail, my lord. 26.
26.
Please, my lords. Admitted case, my lords, of the prosecution itself, that I was not there in Mahendragarh on that date, my lords. I was doing my duty here, my lords.
We are not there.
So,
183 statement of the victim is there. Sorry.
I'm here for the bail, my lords.
Dismissed.
The contents of FIR. May I withdraw it, my lords?
Dismissed as withdrawn.
Grateful, my lords.
3 months. Not interfering, we will request the High Court to decide the criminal petition within 3 months.
But there's no head and tail match between the two FIRs.
Huh?
Two FIRs are totally different.
Be it.
Matter the investigation.
Let them hear the petition. That inures to your benefit also. Impress upon the court that this is absolutely a frivolous criminal petition, should be dismissed immediately.
If I can.
It is listed in the High Court.
Look into it.
5th of June, it's listed in the High Court.
But my lords may say that my lords have not gone.
Having heard Mr. Raju, learned additional solicitor, appearing for the petitioner, and Mr. Kohli, learned senior counsel for the respondent. And considering the fact that the criminal petition is listed for hearing on
5th of June, Lord.
5th of June, 2026.
All petitions, there are 4.
Criminal petition along with other petitions are listed on 5th June 2026. We are not inclined to interfere at this stage. Special petition is disposed of with a request to the High Court to decide all the petitions before it as early as possible and subject to its convenience. Positively, subject to its convenience by August. All contentions are left open.
Sir, nothing on merits.
All contentions are left open.
Deeply obliged, Lord.
करेक्शन कहाँ बोला आपने? Appropriate and just in the factions and so on. We are not granting any further indulgence to the judgment debtor. The decretal property has to be vacated by 30th June 2026 without fail. At the same time, we decline the request of Mr. Kaul at this stage to revise the amount payable. In terms of the order of the High Court, the trial court under Order 20 Rule 12 will determine the amount to be payable. The judgment debtor may rely on the report of Shedgiri. Mr. Kaul can raise all possible objections which were raised before us. And after hearing the parties on their own merits, the inquiry court will dispose of the matter.
Oblige, my lord.
Oblige me.
ये भेज देना ऑफिस में. $29.
My lord, I am requesting for a short date, in fact. The person, in fact, could not come today. So he has made a request to moderate it.
What do you want? Adjournment?
I'm in 29, my lord.
Yes, we have called on 29.
It's 29, I'm in the 29.
Yes.
From the petitioner side.
Yes.
The person concerned, in fact, has to come all the way from Calcutta, and he says that you just ask for the, just make a request for the adjournment.
So why should we adjourn hearing? Because the petitioner wants to be here. He could have joined online.
He is not well aware of it. He is not techno-savvy, man.
Huh?
He is not very techno-savvy, my lord.
He is not very tech-savvy.
Yes.
So we will have to wait for him. When will he come?
No,
then
not-
we will take it up.
Not that, my lord. He has made a request. If we,
He has made a request. Now, this is coming on a mention memo.
yes,
You mention it before the Chief Justice. Chief Justice places the matter and he is not there and we'll have to adjourn.
so that is what he has asked me to do, sir.
You are the counsel. You should have told him.
I have
But this
already
is the Supreme Court. Supreme Court doesn't wait for the client to come from Kolkata to Delhi
Yes.
and then in his presence take up the matter.
Not in.
Then why are you there?
Oh, he has simply engaged me just to file the case.
Simply engaged you to argue the matter.
So let me argue the case, in
Of
fact.
course, you argue the case. Show us where is the error in the order of the division bench.
My lord, in fact, the only thing is that I am not a escapist. I'm not absconding from paying the amount to the bank.
Look here, you have approached the writ court under 226
Yes, my lord.
with a prayer that extend the time for making payment under the one-time settlement,
Yes.
right?
Yes.
The High Court says, I don't have any such power.
No.
Now, if you say High Court has the power, You have to show where does the High Court derive this power of extending the time for honoring the one-time settlement?
My lord, in fact, the single bench of the High Court simply said that, okay, you have got the, you are being given the time to settle the matter. And then the respondent approached the division bench of the High Court, and High Court said no.
Where you show us the error in the order.
My only point is, my lord, that
There is a judgment, incidentally authored by me on behalf of a coordinate bench, where we have noticed previous decisions of the Supreme Court, and we have said that court has no such power. It's a one-time settlement. If you fail to honor the settlement, you have to suffer the consequences.
My lord, I have paid 67.
This is a contract between the two of you.
Yes,
And the court extend the time.
Court may extend the time for.
No, why? Where is the power? Court will extend the time.
Because
They have given you certain terms, that on these terms, one-time settlement can be worked out.
So,
correct?
Just
now you fail to honor the terms. Why will they agree?
They have locked the factory, so our work is not going
So
on.
now you go before the 17 forum and challenge. Right?
Yes, my lord.
We have been apprised by learned counsel appearing for the petitioner that he wished to remain present in court when the special writ petition is heard and decided. Since he has not reached court, a prayer for adjournment has been made. Stop. We record that the court cannot wait for the litigant to reach the court to witness court proceedings. Stop. We have heard Mr. Swensel and counsel for the petition and are of the considered opinion that the division bench of the High Court has correctly observed that the court has no power to extend the time for working out the one-time settlement reached by and between the secured creditor and the borrower. Stop. The order of the division bench under challenge does not suffer from any error, and therefore the special writ petition is dismissed. So we have additionally recorded what you submitted.
Okay, my lord.
May please, Lordship. One request, Your Lordship. The other connected matters are coming up tomorrow. The main matter. If this SLP can be taken up, okay, with those matters tomorrow, because it has far-reaching consequences.
Tomorrow.
The state is also fair.
18458 SLPC 184.
They will give
Yes, we filed it. We've mentioned it to come up tomorrow.
with the other matter too.
Please, Lordship.
My lords, in item 31, I'm requesting for a passover.
Over.
My lords, the senior is on
It was there on Tuesday. We adjourned it. Maybe it was not called on yesterday, but today again Passover.
My lords, the senior is on
Passover. But remind us before we rise.
Yeah, please.
Specific order was passed.
We are in 31, madam, which we have passed over.
No, but it's 32 is Shilpa Goldie Su.
No. Shilpa Goldie Sood is 31. We have passed it over. 32, yes, Mr. Singh, where are the matters?
Got the latest information provided
Yes.
by the Subordinate Service Election Commission. I just passed it and I've got only one card.
Before my learned friend passes on, 23rd of November, Lordship's framed questions.
23rd of
November, last year, we did part third. And those questions pertain to the vacancies of 2015, 16, 17. Now, this news story is being spun up that it never applies to the court. 5 adjournments took place. That new selection process has started. In a partner matter, one was like violation of law.
Just one more thing to add to what Mr. Mukherjee said. There was a question raised in the UP Assembly. There, my lord, the state government clearly said that total sanctioned posts as on 2023 was 7768, out of which vacant posts are more than 5,000. More than 5,000.
Give the other copy. Second copy.
Yes,
Send second copy.
Okay.
Acha, you have given.
Lordship, may kindly have the order for last day.
Second page is the English translation, my lord. More than 5,000 vacancies. And there's no recruitment post 2023. As on.
Mr. Singh, if this is right, we do not know whether this is right or wrong.
What I say this,
If
on the
this
last
is
date,
the statement in the well of the assembly.
left out vacancies of 2004 advertisement. They were advertised in 2022. But in that month, there were a number of 406. Out of 406, my lord, 2,406. But this was the lordship last order, my lord.
File your written submissions before court partial working days. Judgment is reserved.
Obliged.
Let's in item number 32.2, we have two implement applications.
1 week. 1 week to file.
We are giving you more than 1 week.
Lord,
We are closing on 29th March, 29th May. So we are giving you more than 7 days. 10 days time you have.
Much obliged.
Written submissions by 29th.
Obliged.
My lords, in
I appear for the commission, my lord.
Acha, UP Commission.
Only on the factual part, my lord.
Yes, yes. Just 1 minute.
Yes.
Mr. Mukherjee.
Yes, commission.
Lord, I provided the information to Mr. Singh. Lord, there were 2,406 posts, out of which,
Left out.
as per the order, my lord.
No, that is what he submitted.
Yes.
We have recorded.
Yes, the total number post is correct. Lord, the unfilled post was 555, not 675. Lord, and those 555 pertain to various categories, Lord. I have prepared a detailed chart, Lord. I'll file it with my submission.
But what about this answer in the assembly that 5,000 are vacant?
That I
Have you seen that?
Yes, Lord, I just peeped over it from.
So we are also granting you liberty.
Yes,
You may not be a party to the proceeding.
I am, my lord, in one of the matters.
In one of the matters.
Yes, my lord.
So you tell us
Yes, my lord.
in your written note whether this, what Mr. Sen has just now placed before us is right or wrong.
Yes, my lord. I'll take instructions on that.
We are passing this order. You come back on Monday and tell us.
Lord, they,
On instruction.
Lord, this commission.
On instruction,
Yes.
just tell us whether, because if it is wrong,
Yes, my lord.
then we will have to
Yes. Lord,
put the matters back and rehear.
Lord, actually, the vacancy will be under different recruitments. So I will give that detail. I'll get that detail.
Monday,
Yes.
Justice Masi may not be with me,
Yes, my lord.
but we grant you liberty to come and say
Yes, my lord.
whether this question was put in the assembly by one legislator
Yes, my lord.
and whether the concerned minister gave this reply or not.
Yes, my lord.
If it is yes, one consideration. If it is no, different consideration.
I understand, Lord. That's the reason why, Lord, I'm making this submission. Lord, I just wanted to clarify, Lord, the role of the commission is that we receive requisition from the department.
We know your role.
Yes, yes.
We know your role.
Yes. On
Mr. Singh, you can also obtain instructions and then let us know on Monday.
Yes, my lords, and
32.2. May I say this, Plus, we have filed an intervention application along with directions. One is plus 95986 and 95986.
All intervention applications we will deal later.
Plus,
We will deal later. Let us first get the information on Monday. Then we will consider, because you may be all fence sitters. All fence sitters. Now filing for implement. Very difficult.
The commission will also take into account the 23rd of November. because that
Very well, we'll consider. All implement applications will be considered.
Sir, whatever. Yes, sir.
Huh? Reserved. Monday they will just come and mention. Monday they will come and mention. And if possible, Mr. Mukherjee, Mr. Sen, your juniors may be present in court.
Yes, yes.
Because if they come and say that this is incorrect information, then whoever has supplied that information will be taken to task.
It's not right now. But anyway, I think it's the correct information. Whereas Monday, I think it will be virtual. I think
Monday will be virtual.
Lord, it's actually optional. In the sense
Monday
that
will
it's
be
not
virtual, right? You are right. So all of you be there.
We'll show our face.
Lord, I'll, my lord, try and send a colleague, my lord, so that can be handed over. Grateful, my lord.
Very well. 33.
My lord, state was directed to seek instruction
Lordship,
whether
all-
they have filed 65B certificate on record or not, my lord, on the previous.
All documents are already on record, Lordship. I have checked it. I'll argue on merit.
My lord, may I submit, my lord, specifically directed state to whether they have filed on the record, trial court record 65B certificate or not. Specific, my lord, he was directed. But I have filed, my lord, the original records in separate room, my lord. There is no certificate available on the records, my lord. They have not filed.
If I may, Lordship, I'll explain.
Just give a brief outline of the matter.
My lord.
Student of class 12.
My lord, I'm just. My lord, the incident was happened on 25th of December 2015, my lord.
Yes.
And on the same day, my lord, the father of the complainant filed a complaint. That is at page number 27, my lord, which doesn't reflect my name, petitioner name, my lord, first. Thereafter, my lord, the same day, the police reached at the spot and in the said incident room. Thereafter, recovered the one suicide note that was the original, my lord, and one Samsung mobile, my lord. And after searching whole the rooms, my lord, and that was seized. And there were two witnesses. They signed, and father and mother were present there. My lord, that suicide note also doesn't contain my name. That is the original one, my lord. That is on the record. I'm not questioning on that. But thereafter, my lord, the second complaint was filed by the father, which also doesn't contain my name. FIR doesn't contain my name, my lord. My name came in during the investigation, my lord. Thereafter, my lord, kindly see page number 41 CDR, my lord.
You were also not named in the charge sheet.
Yes, my name was came during the investigation, my lord, but I was exonerated because of my lord, IU didn't find anything. Even as per the CDR, there was no call details between me and deceased, my lord. There's nothing on the record. That's why, my lord, my name was deleted from the charge sheet. Thereafter, my lord, their cases, they said that these articles, chip, my lord, one chip they found, wherein they found the one photocopy suicide note and one audio, my lord. They filed, my lord. They said the police refused to take. Thereafter, I filed this after 2 years, my lord. This is their case.
Clarification. Police filed the charge sheet.
Yes.
You did not figure as a charge sheet accused.
Yes.
The complainant, did he file any protest petition?
No, my lord. No, nothing.
Nothing.
No protest application, no during the charge framing, no.
Therefore, now you have been summoned under 319.
Yes, directly, my lord. Based on this article, my lord, without support of 65B application, even summoning application doesn't support any affidavit, my lord. Kindly see there, my lord. Should I show the summoning application first? My lord, kindly see the.
We just complete the narration in the list of dates.
Yes, my lord. Come. Thereafter, my lord, kindly see the.
We have come to charge sheet, petitioner not named, 5th of December 16.
Yes, my lord. That's correct.
Then trial court frames charges.
Thereafter, my lord, one purchase number 11 was filed in the charge sheet, which thus correlate the CDR of mine and deceased, my lord. They specifically. Yes. Thereafter, my lord, they clearly stated that IO, there's nothing, no CDR, no details, no calling with the petitioner, with the deceased, my lord. There's no connection with that. Thereafter, my charge sheet was filed, my lord. The trial was commenced, charge was framed against the Pintu Sarkar. He is the main accused, my lord.
Right.
And thereafter, my lord, on 18th of May 2017, PW1 testimony was recorded.
Yes.
My lord, he is the father of the deceased, wherein, my lord, he is just silent.
About
in
your role.
chief examination, he is silent about these chips, all these things. And thereafter, my lord, PW2 also deposed there. She explained during the
PW2?
Mother of the deceased.
Mother of the deceased.
My lord, PW1 is silent. He doesn't know. He didn't depose anything during the chief examination. I'm not coming to the cross examination, my lord. PW2 stated the story of chief, my lord, after 2 years from the date of the FIR. Before that, they didn't raise this particular issue during the framing of charge. They did not file the protest application. They did not question about the further investigation, all these articles, my lord. Their case is, my lord, they said that the police refused to take these articles and they said you should produce in the court. My lord, even they denied this aspect. I never given this particular article to the police in the during the cross-examination, my lord. They given this particular article to during the posing the bail before the High Court, my lord. My lord, kindly see the summoning application, my lord. I want to show, my lord, kindly see the page number. Page number 68, my lord, kindly.
Page 68.
Yes, this is the summoning application. After 2 years, just with the planned manner, they have moved. This is the moved by the PW1, father of the decision, my lord. Can I see? Even they did not describe about the chip, about the audio recording, my lord. Nothing in this. Even there is no detail about the details of the chip, which company, capacity of the memory, my lord, whether it is readable or not, nothing else, no description. And also they have said, that is on the record, my lord, they have said the chip was broken. I do. Huh? My lord, kindly see the page 70. This is the order of the court, that is on the record, my lord, 7th line. Archana Gupta broken memory and was found torn in the language when she came home.
You are reading which page?
Page number 70, my lord.
70.
This is the order, my lord, wherein they are asking that just I want to put the audio clips and chips on the record, wherein it is there is a, my lord, kindly see the 7th line. Archana Gupta, a broken memory card was found torn in the language when she came home. My lord, the chip, whether chip was readable or not readable, how they restore the data. My lord, in these circumstances, the certificate, this is the kind of secondary evidence, my lord. It is a case of no evidence. My lord, without any certificate, there's nothing, my lord. This order was passed. Thereafter, in this matter, they were directed to just their chips were taken on the record. My lord, kindly see the page number 72, bottom. At this stage, the chip has been filed from the list dated so and so, the application so and so, be listed for in so. Even there's no, my lord, there's no 65B application, because of they are relying upon these evidences to implicate me, my lord, at the stage of 319. There must be a strong evidence. And thereafter, my lord, they have filed one audio recording which is between the Pintu Sarkar, my lord, main accused and deceased. That is that is also not supported by any certificate, my lord, whether that is true, false. My lord, can you see? Even, my lord, that's not considered with me also. Everything, my lord, depend on the chip, my lord. They have found suicide note. That is the photocopy of suicide note. The original is not on the record. It is my case, my lord. And this is the articles, my lord. That is the conversation between the Pintu Sarkar and deceased. I do not have any concern, my lord. They are relying upon over this, my lord. My lord, even the summoning application is not supported by any affidavit, my lord. There's nothing, my lord. I have filed, my lord, all the order sheets, my lord, between the relevant period, my lord. They have not sent even the trial court did not ask status report regarding these articles, my lord. Nothing is on the records. My lord, that's why, my lord, my case is that the summon was issued contrary to the, my lord, the judgment and parameter laid down in Hardeep Singh, my lord, case 105 and 106 paragraph, which says there must be cogent and strong evidence, my lord, at the stage of 319. My lord, this is the, my lord, if I believe PW1 and PW2 statement right now, based on the chip, that cannot be also relied upon, my lord, here. So this is my case, my lord. That's why, my lord, the trial court committed error, issuing summoning without any certificate, without any strong evidence. It is a clear case of no evidence or
Yes.
My lord, I want to refer judgments on the point. My lord, my case is clearly, my lord, there is no strong at this stage of 319. My lord, to whom I should corroborate. My lord, if someone is justified rightly, my lord, to whom I should corroborate during the examination, my lord. There's nothing on the record, my lord.
Which judgment you want to rely on?
My lord.
Hardeep Singh.
My lord, Hardeep Singh. And
Bas only Hardeep Singh is enough.
one more judgment here
It's
also.
the Constitution bench judgment.
Yes, my lord.
You have a compilation.
Yes, my lord.
Very well, hand it over. Yes, madam.
Lordship. The entire argument that the order was based on the chip is misconceived, Lordship. His argument is that the application under 319 was allowed, relying upon the chip which was not supported by a certificate under 65B. So the examination of that order is very important. Bare reading of the order would show that it clearly says that the chip was taken on record. However, it was not proved. It relies upon the deposition of PW1 and PW2, where clearly...
It's the deposition of PW.
Yes, Your Lordship. The deposition of PW1 and 2 starts at page 49. I will point out the paragraphs, Lordship.
49.
Page number 49 is the statement of the father.
Yes.
If Your Lordship may permit me, page number 50, where the role of the petitioner can be culled out. I'll just read it. Last line from page number 49. At the time, Ragini and her daughter met, and Ragini took the mobile number of my daughter. And by calling regularly, Ragini used to get her husband, Pintu Sarkar, and her friend Sonu, that is him, to talk to my daughter Archana. All three used to talk obscenely with my daughter and used to invite her to meet outside. They also used to come at the room of my daughter. My wife had also told these things previously. Therefore, I called and scolded Pintu, Ragini and Sonu. Again, his name is there. Sonu, son of Muni Jaiswal, is resident of so-and-so. Pintu often used to talk obscenely from his mobile to my daughter, which she used to tell to her mother. Ragini had made an obscene photo of my daughter by calling at her beauty parlor, in which Pintu and Sonu were also involved. So complicity of the petitioner is clearly made out from statement of both PW1 and PW2. Even PW2, if Your Lordship may permit me, I will point. Starts at page number 57.
Does the suicide note implicate him?
There are two suicide notes, Lordship. One has Pintu's name and the other one has Pintu and his name.
So one was pasted on the wall.
Yes, Your Lordship.
And where did the other suicide note come from?
Lordship, it is the case of the complainant that she was a student, a minor, 17-year-old child. She was raped multiple times by these three. Ragini,
by the three? Ragini?
The Ragini was running a beauty parlor. She was also complicit. And it is the case that when the parents went after her death, when the parents went to her place where she was residing, they found a bag in which there was a chip which was found with 15 audio recordings. There was a photograph and there was a suicide note which was found from inside her bag. They went to the police, who refused to take the evidence, and that is why it was brought on record later by the complainant. That is their case, Lordship, the complainant's case.
Did the chip surface for the first time?
The chip surfaced for the first time after 2 years, from what I understand.
Lordship, may I am for the complainant, Lordship. Lordship, the articles of she was living in a student and living in a rented accommodation. So police recovered at the time of inquest. Thereafter, her articles were taken home. Then there was one bag. And in one bag, after around 1.5 years, after that, these things.
It's very unfortunate that you have lost your daughter. But when you take back belongings, is it believable that after 1.5 years or 2 years, you will be searching the bag and trying to find out what is there? Huh?
Lordship,
the proof has to be more than prima facie. Stronger than prima facie, as per Hardeep Singh.
Lordship, they approached the police.
Why did you not file a protest petition? When the charge sheet did not indicate that Sonu is not being arraigned as a charge-sheeted accused, what were you doing? You say in your examination that Sonu was harassing your daughter.
Lordship.
You knew everything. Why didn't you file a protest petition?
Lordship, because the police, when we approached the police did not take and said you approach the court. Meanwhile,
The
bail
protest
application.
petition is not before the police. Protest petition is before the court.
My lordship, these are not so aware litigants, my lordship, poor persons.
No,
And
you
if,
say
if
at
the
up to
advocate,
page 50, sir. See your evidence. Page 50, you have scolded Sonu. You say that Sonu was on talking terms with your daughter. He used to talk obscenely with your daughter,
Lord,
and for which he was admonished by you. So you knew this before your daughter passed away,
lordship, this is
and still you don't file a protest when Sonu is not arraigned as an accused.
lordship, this is father's testimony, and he was informed after the death by the mother. Mother was aware, but she has not disclosed to her the
Sir,
husband.
please, you don't make submissions contrary to the evidence. Please come to page 50. Therefore, I called and scolded Pintu, Ragini and Sonu. Either you don't know Sonu or you know Sonu. Please see page 50.
Lordship, if Lordship may permit, Lordship, the entire thing about the incident, it was only means what little bit was informed, and therefore he has scolded that they are harassing, but he wasn't aware
Now,
about
come to page 51, paragraph starting, I have not met Pintu Sarkar before this incident. And you say that I called him, warned him.
He has not met, but he has called on
How
phone.
how did you scold and warn him?
On phone, Lordship.
On phone, three of them together.
Telephonically. He has not met.
Judgment reserved.
My lord.
Lordship, may I
No.
I wanted to place a case law, if I may.
Lordship,
Please file your written submission
Lordship,
by Monday.
grateful.
CAV.
May it please not. Lord, if your lordship permit, I'll give a brief recapitulation of what we had argued last time. I am the petitioner.
Yes, Mr.
Now, my lords, the point here was, before I take your lordships to the list of dates, very briefly, the point was that, my lords, I am an award holder. They are the award debtors. I filed an execution, my lords, just on the cusp of, my lords, coming of the Commercial Courts Act. My execution, my lords, for some reasons, remained pending before the learned principal district judge, who, my lords, for administrative reasons, transferred it to the family court, who was also a district judge. So, my lords, there were sales, there were auctions, there were objections by them. Everything was decided by that court as an execution court, my lords, after the award. There 34 in the meantime came to be filed and dismissed by a detailed judgment, my lords. There 37 is pending under defect for more than 1 year, I am told. They have not, my lords, brought it up for hearings. Now, my lords, there were 4 orders which were passed by the learned execution court with regard to some auctions and sales, which I will tell your lordships in detail. My lords, 3 revisions came to be filed by them before the Honorable High Court, and 1 revision came to be filed by me on merits of the matter, my lords, on merits of those orders by the learned execution court. Now, the Honorable High Court, by way of the impugned judgment, my lords, relies on Delhi High Court and, my lords, Honorable, which is the other one? Kerala High Court. We have placed a compilation of all judgments against us and in our favor, my lords, saying that the commercial court only had jurisdiction to, my lords, hear an execution post an arbitration award. Therefore, whatever has been done till date by the execution court, which was not the commercial court, has to be effaced from the record. It's quorum non judice. Everything is null and void. So all orders set aside. I have to pursue my execution afresh after all these years in the commercial. Lord, this is the summum bonum of the proceedings so far. Lord,
just set aside all execution in this
Huh.
case.
So everything was set aside. And Lord, the impugned judgment says all execution orders passed in the state, Lord, will be set at nullity. I'll show that. So Lord, we had quickly, if I can just, Lord, recap the provisions, because before I come to the impugned judgment, the provisions of the Arbitration Act, Lord, and the Commercial Act would be very relevant. Our submission was that after the award, the arbitration proceedings, Lords, are terminated as per Section 32 of the Arbitration Act.
Thereafter, section 36 says that execution will be treated as if it was a decree under the CPC. And therefore, my lord, secondly, Commercial Courts Act, when it amends CPC, my lord, for its applicability of different provisions to the commercial courts, then, my lord, it ends at order 20. It does not take it forward order 21 onwards. So even the Commercial Courts Act, my lord, leaves execution of an arbitration award or of any other decree open for being executed, my lord, in the civil court. So, my lord, this was our submission. A quick purview of all the provisions, my lord, very quickly I will read them. So that, my lord, the point I am wanting to make, I can, my lord, then. Please have the Arbitration Act, my lords, to begin with. Judgment compilation. But Lordship may have section 2, subsection 1, clause E, court means. The issue will be, my lord, the Commercial Court Act says suit or any application. Arbitration, no doubt, a commercial dispute, my lords, I'll show from the Act. But suit or an application. So the Honorable High Court Division Bench in our case says, my lords, in the impugned judgment, that execution is also an application. Now, my lords, please have section 2(1)(e). Court means, in the case of an arbitration other than international commercial arbitration, the principal civil court of original jurisdiction in the district and includes the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of the arbitration, if the same had been the subject matter of a suit, but does not include any civil court of a grade inferior to such principal civil court or any court of small causes. So, my lord, like for example, in Delhi, even the Honorable High Court can be, my lord, subject to pecuniary jurisdiction, the principal court of original jurisdiction. In Haryana, it will be the learned district judge. Now, my lords, the Act envisages several applications. Like section 8, if a suit is filed, despite there being an arbitration agreement, my lord, so somebody can file an application under 8. Section 9, my lords, is interim measures, lordship knows. Section 11 is appointment of arbitrators, etc. Then section 16 to challenge the jurisdiction, and all of these applications, my lords, are applications, is our humble submission. Now, please have, my lords, section 21. My lords, is commencement of arbitration with a notice. And then please have 32. My lords, is termination of proceedings. This is the section we are, my lords, humbly submitting and pressing upon. The arbitral proceedings shall be terminated by the final arbitral award or by an order of the arbitral tribunal under subsection 2. In our case, award was passed, so proceedings, my lords, came to an end except 34 and 37. Then your lordships will kindly have, my lords, 34 of course is setting aside, which they filed and it has been dismissed. Then please have, my lord, section 36, which says, my lords, enforcement. Where the time for making an application to set aside the arbitral award under section 34 has expired, then subject to the provisions of subsection 2, such award shall be enforced in accordance with provisions of the CPC in the same manner as if it were a decree of the court. My lords, please mark this.
The arbitration law was amended after the Commercial Courts Act. This provision was not amended. 2016 it was but it
Good. Yes. Now, my lords, what is important is lordship may mark in the footnote of the Bear Act, this section 36 was amended. Lordships will recall, my lords, earlier 34 was a per se stay. Then 36 was amended to say that court will impose conditions. This amendment comes after the Commercial Courts Act, my lords, has been put into enforcement. No, it is the same date. Yes. It's the same date. I'm sorry, my lords. 23/10/15 Commercial Courts Act. And 23, 10, 15, this section 36 is also amended.
Bouquet of amendments.
The act is called Act of 2016, but it came with effect from 23, 10, 15. So it was a bouquet. My lords, even then, this provision, my lords, is not mentioned to say that it will only go to the Commercial Courts Act. The execution, I mean, lords, which is called enforcement, lordship knows, my lords, when it comes to an arbitration award.
Arbitration. How to come.
This, my lords, was the scheme of the Arbitration Act. Now, lordships, please have, my lords, the Commercial Courts Act. Lordships is not section 1, subsection 3. It's the same date on which the Act 3 of 2016 amending the Arbitration Act was enforced. Same date here, my lords. Section 1, subsection 3, my lords, it says it shall be deemed to have come into force on the 23rd day of October 2015. Now, please see section 2, my lords. Small b, 1b says commercial court means the commercial court constituted under section 3, subsection 1. Commercial dispute means a dispute arising out of. Your lordships have read this several times, lords. Arbitration will come later. I will show that, lords, we are a commercial dispute, no doubt. Then, lords, section 3 is constitution of commercial courts. The state government may, after consultation with the concerned High Court by notification, constitute such number of commercial courts at district level as it may deem necessary for the purpose of exercising the jurisdiction and powers conferred on those courts under the Act, provided that with respect to the High Courts having ordinary original civil jurisdiction, the state government may, after consultation with the concerned High Court, by notification, constitute commercial courts at the district judge level. In our case, my lords, the Honorable High Court is not a court of original jurisdiction.
So what is the date of the award?
The date of the award, my lord, is 13/10/2015.
13/10/15.
Yes, my lord.
Date of 34 dismissal is?
34 dismissal is, my lord, 2000, my lord, no, just give us a moment. It is 2025. We have placed that, my lords. Section 34 was dismissed on 29/4/2025.
29/4.
2025. And the dates relevant for section 3 are given by the Honorable High Court, my lord, at page 34 of the paper book.
Ten days before this. We discussed it.
So, my lord, the next section is section 6.
Yes.
Jurisdiction of commercial court. The It says, my lords, the commercial court shall have jurisdiction to try, please mark, my lords, all suits and applications. So anything which is in the nature of a trial relating to a commercial dispute of a specified value arising out of the entire territory of the state over which it has been vested territorial jurisdiction. Explanation: for the purposes of this section, a commercial dispute shall be considered to arise out of the entire territory of the state over which a commercial court has been vested jurisdiction, if the suit or application relating to such commercial dispute has been instituted as per the provisions of section 16 to 20 of the CPC 1908. Now, my lord, lordship may only mark, normally such a statute can also have a provision that the civil court jurisdiction is excluded altogether. My lord, there is no such provision in this act. No, section 10.
Yes.
Then, my lords, arbitration is commercial is section 10 of this act, jurisdiction in respect of arbitration matters. Of course, this has to be above the specified value, which is 3 lakhs not. So there is no dispute in our case. It is above 3 lakhs. Section 10 says jurisdiction in respect of arbitration matters. Now please see 11, my lords. This is the reverse exclusion, bar of jurisdiction of commercial courts and commercial divisions. Notwithstanding anything contained in this act, a commercial court or a commercial division shall not entertain or decide any suit, application or proceedings relating to any commercial dispute in respect of which the jurisdiction of the civil court is either expressly or implicitly barred under any other law for the time being in force. Now, my lordship may kindly have 12 lordship may leave, my lords. 13 is also appeals. Please have, my lord, section 15. I'll read, my lords. Please go ahead. Chapter 5 itself says, my lords, transfer of pending suits. Then section 15, transfer of pending cases. All suits and applications, including applications under the Arbitration and Conciliation Act 1996 relating to a commercial dispute of a specified value pending in the High Court where a commercial division has been constituted, shall be transferred to the commercial division. Now this, in my humble submission, my lords, was to be done by the Honorable High Court on the administrative side. If it thought that, my lords, only a commercial court would have, my lords, jurisdiction to hear executions pending all across the state, not only my execution, my lord. This was never done.
Yes.
My lord, similar is subsection 2, all suits and applications, including applications under the Arbitration and Conciliation Act relating to a commercial dispute of a specified value pending in any civil court in any district or area in respect of which a commercial court has been constituted, shall be transferred to such commercial court. So since the Honorable High Court, there is not ordinary jurisdiction, civil jurisdiction, therefore 2 will apply. All execution should have then been transferred, my lords, by the Honorable High Court. Provided that no suit or application where the final judgment has been reserved by the court prior to the constitution of the commercial division or the commercial court shall be transferred either under 1 or subsection 2, where any suit or application, including an application under the act relating to a commercial dispute of specified value, shall stand transferred to the commercial division or commercial court under 1 or 2, the provisions of this act shall apply to those procedures that were not complete at the time of transfer. This is important, lords. I'll show you lords why. Please have subsection 5. In the event that such suit or application is not transferred in the manner in subsection 1 or 2 or 3, the Commercial Appellate Division of the High Court may, on the application of any of the parties to the suit, withdraw such suit or application from the court before which it is pending and transfer the same for trial or disposal to the commercial division or commercial court, as the case may be, having territorial jurisdiction over such suit, and such order of transfer shall be final. Now, why that is important is, I have said about the Honorable High Court. The other side, my lord, the award debtors also never filed an execution, an application to the Honorable High Court saying that this execution is wrongly going on in the court of the learned district. It was for the first time. I will show to your lordship, lord, and your lordships have held in 2023 and recently. That, my lords, if you do not take an objection, first time in the High Court on the appellate jurisdiction not allowed.
Yes.
My lord, section 16. Chapter 6 says, my lords, amendments to the provisions of CPC. Now here, my lords, the distinction comes how, my lords, commercial courts will expedite, my lords, the commercial suits. Section 16 says, amendments to the Code of Civil Procedure in its application to commercial disputes. The provisions of the Code of Civil Procedure shall, in their application to any suit in respect of a commercial dispute of a specified value, stand amended in the manner as specified in the schedule. The commercial division and commercial court shall follow the provisions of the CPC as amended by this act in the trial of a suit in respect of a commercial dispute of a specified value. Please mark, note, trial of a suit, where any provision of any rule of the jurisdictional High Court or any amendment to CPC by the state government is in conflict with the provisions of CPC, as amended by this Act, the provisions of CPC as amended by this Act shall prevail. So, my lords, please see the schedule now, which is after section 23.
Yes.
My lords, I only have to submit for the schedule that when your lordship reaches towards the end of the schedule, my lords, your lordship will find it ends at order 20. Please see clause 11 of the schedule, my lords. So the schedule, my lordship knows, provides for how, say for example, beyond 120 days in a commercial dispute, no written statement come what may. Similarly, it has been amended for other provisions of CPC. So the last provision is, my lords, clause 11, amendment of order 20. Lordships will find clause 11, my lords, of the schedule. Clause 11 is, my lords, amendment of order 20. Lordship, this is Masih has. Now it says, my lords, amendment of order 20. In order 20 of the code for rule 1, the following rules shall be substituted, etc. After this, my lords, giving one appendix of statement of truth, the schedule comes to an end. So order 21 and thereafter, my lords, for us it is order 21 execution, which is a complete code in itself, is not referred to by the Commercial Disputes Act. My lords, the object is to expedite. If executions were to be, my lords, undertaken with a different procedure, this Act would have mentioned it. So it does not really matter whether the learned district judge, my lords, decides an execution or the learned commercial court. There is no distinction in the Act. The Honorable High Court says the object was to expedite. I am rather being set back, my lords. Now, my lords, this was about the scheme of the provision. Section 9, of course, I do not need to cite. Section 9 CPC is, my lords, the classic example that civil court will have jurisdiction, my lords, unless specifically excluded. So this Act does not specifically exclude. Now, my lords, we'll take your lordship through the impugned judgment. It has only relied, my lords, on the Honorable High Court records their submissions, my submissions, then, my lords, relies on two judgments. My lords, we have given a compilation last time. We have placed all the judgments there, my lords, in our favor and contrary. If your lordships can just take that, my lords, I'll quickly take your lordship through all the judgments.
First, let us see the impugned
judgment. I'm grateful. Now, my lords, the background of the impugned judgment, I had told your lordships at the outset. In my execution, my lords, there were two properties which your lordships will call properties A and B. For those two properties, I, as the award holder, myself purchased them for about 6.5 crores, and that was allowed to be set off against my decretal award. That was one order which they challenged. I'm just giving your lordships the background so that it becomes easier to appreciate the impugned judgment. The second order challenged by another party was, my lords, that there were two properties called D and E, which were in the nature of, my lords, windmills. That auction had also happened, but the learned execution court, my lord, decided the third party objections against me, saying that I did not have territorial. So that was my revision, which I filed. Two revisions, my lord. Sorry. Now, my lord, so the third revision by them was that with respect to A and B, after the auction, my lords, is accepted and their objections are dismissed, sale certificate is directed to be issued in my favor. So that was the third revision. And the fourth revision was against the ministerial order of issuance of sale certificate itself. So these were the four revisions, my lords, in the pending execution before the Honorable High Court. Now, my lords, please have the impugned judgment. Starts at page 1, my lord. Contentions are recorded. Lords, his contentions are summed up in page 13, para 11, and his judgments are also cited, my lord, which I will just immediately cite, lords, after I complete reading. Lordships may see para 15 at page 15, my lords. The contentions of learned counsel can be summarized as under. These are their submissions. The value of the award is above 32 crores. It is far above the commercial value, no dispute. Since the commercial court at Vijayawada is constituted to exercise jurisdiction over the district at Anantapuramu, the EP cannot be entertained by the 7th Additional Learned District Judge, Anantapuramu, and the said court lacks inherent jurisdiction to pass orders. He submits that as it is a case of inherent lack of jurisdiction, he can question the same at any stage, and therefore he has raised the issue before this court. Then, Lords, in reply, our submissions start. These are essentially what I have submitted before your Lordships, Lord. And then, Lords, the analysis will start. Lordships will find page 23, bottom, Lords. Para 20, this is analysis of a submission.
So the analysis starts at 18 of the existing, page 18, para 18.
Yes. Page 18, Lords, the analysis had started. Lordship may come to after reading the provisions. Para 25, Lords, page 23, bottom.
Yes.
A reading of these sections and amendments in seriatim shows that intention of the legislature was only to modify and streamline the procedures and practices relating to suits and applications in suits, etc., which are pending for disposal. The heading of Chapter 6 of the Act is amendments to the provisions of CPC. The amendments to CPC refer to the first schedule and specifically to orders 5, 6, 8, 11, 13. And in addition, a newly corporated order 15A is brought into force. All of them deal with the trial and disposal of a suit only. This is what we are saying. None of the other provisions of the CPC are touched or amending, including Order 21 CPC. In the opinion of this court, this deliberate silence, now Lord, this is important. This in our humble submission is not in a way judicial legislation. In the opinion of this court, this deliberate silence by the legislature, in spite of the need for a law on the subject for quick and efficient disposal of the cases, including commercial disputes being on everyone's mind, makes it very clear that the legislature in its wisdom decided to speed up the trial and disposal of the cases in the commercial court alone. Time and again, the Honorable Supreme Court of India and various courts have spoken about the need for quick disposal of domestic and international commercial disputes. Lordship, then skip a few lines, Lords. Page 25, top. Second line from the top, Lords, page 25. The silence or failure to refer to Order 21 does not mean that the commercial court cannot execute a decree. Our alternate submission is commercial court may, if the Honorable High Court feels, but civil court cannot. That's wrong. A purposive interpretation has to be given to the provisions of the Act. If it is not so interpreted, the commercial courts will be powerless in many aspects. If the arguments of learned senior counsel for respondent are further extended, and as other provisions of CPC are also not touched upon, referred to, it would mean that the commercial court cannot add or delete parties, because Order 1 it says is not included, cannot bring on record the legal representatives, Order 22, cannot grant injunctions, Order 39, order attachment or arrest before judgment, Order 38, and so on. These are a few illustrative aspects that are touched upon. This would virtually render the commercial courts non-effective and virtually defeat their purpose. Can it be said that since Order 38 or 39 are not mentioned, the commercial courts cannot grant an interim order? This would lead to a collapse of these courts. Now please have, Lords, para 31. This will be, Lords, page 27.
These are all applications which are connected to the suit.
Yes, my lord, I am grateful. So if I file a 39 1 and 2 has to go to para 31, my lord.
Para 31.
Para 31, my lord. In our case, in every case. This will be at page 27. Lord. Further, in this court's opinion, the word application occurring in section 15 of the Act is also not limited to original applications or only or to application in suits. Support can be drawn from the provisions of Order 21 CPC itself dealing with execution. Order 21 rule starts with the words application for execution. Rule 11 says an oral application is permissible. Order 21, Rule 11 talks of a written application. Similarly, Rules 11, 8, 12, 13, 16 talk of applications for execution. The use of the word suits and applications, including applications under the Arbitration Act 1996, make it clear that it is not merely limited to suits and arbitration applications only. An inclusive definition is given to include all applications under 15. the intention of the legislature is also clear from a reading of Section 10 of the Commercial Courts Act, which deals with applications and appeals under the Arbitration Act. They are dealt with under this section. The court therefore holds that the word application in Section 15 includes execution applications also. The inclusive definition in Section 15(1) makes this clear. Then, Lord, Section 36 is cited. Then these are judgments which will just immediately come to, my lords. Now please see para 35 at page 31 bottom, my lord. There cannot be two courts, fora, one for the dispute resolution and one for execution of the decree passed. The Act itself makes a distinction. It stops at order 20. Section 38 of CPC clearly states that the decree may be executed by the court that passed it or the court to which it was sent for execution. Therefore, this court holds that a commercial court can execute a decree passed by itself or even execute a decree sent for execution under 15 of the Commercial Courts Act or by transfer from another commercial court. For all of the above mentioned reasons, it is held that the commercial court has jurisdiction to execute its own order or a decree transferred or sent to it where the value is above the limit. This court respectfully agrees with the views of the Kerala and Chhattisgarh High Courts. Now here, my lord, it seems to be a factual error because the Honorable High Court has done actually the reverse. Kerala and Chhattisgarh are in my favor and respectfully disagrees with the views taken by the other learned judges of the Gujarat, Delhi. Gujarat, Delhi and Rajasthan are against us, my lord. Then, my lords, Gujarat is cited, against which it is said that the SLP has been dismissed, my lords. No doubt by a limine order, it has been dismissed. Now, please have, my lords, para 42. Page 34, bottom, lord. Lord, these are the facts on which all this controversy surrounds. Para 42, lord, bottom of the page. Award on 13/10/15, 23/10/15, the Act comes into force. 18/1/16, post the Act, no doubt, I file my EP, my lords, before the learned district judge. On 10/6/16, now this is important, my lords, GOM issued by the state of Andhra Pradesh, by which all the principal district and sessions court were designated as commercial courts in Andhra Pradesh. On 16/5/19, GOM 78 was issued constituting only two commercial courts in the state of Andhra Pradesh at Vijayawada and Visakhapatnam. It is therefore clear that by 18/1/16, when EP was filed, the commercial courts were not formally constituted in the state of Andhra Pradesh. On 10/6/16, all the courts of the district and session courts in Andhra Pradesh were designated as commercial courts. From 10/6/16 till 15/5, this should be 2019, Mulaj. This is a typographical error. This position continued. However, with effect from 16/5/19, only two commercial courts were designated over all the 13 districts. The family court, Anantapuramu, was entertaining the EP consequent on the transfer by the learned district judge on 27/8/19. Therefore, the matter was pending before the 7th learned ADJ, Anantapuramu. In view of the conclusions arrived at by this court that it is only the commercial courts that have the jurisdiction and authority to execute the judgment and entertain the EP, this court has to hold that with effect from 16/5/19, it is only the commercial court at Anantapuram which could entertain the execution petition or pass orders. No other court could pass orders in view of the conferment of the exclusive jurisdiction on the commercial court. Then, my lords, page 37 is where we argued that they have participated, and I'll press on two judgments for this, my lord. That was rejected. Page 37, if your lordship sees, about 7th line from the top, my lord. Other cases to argue that defect of jurisdiction strikes at the very root to pass the order, and that participation of the revision petitioner or the failure to raise an objection will not clothe the family court Anantapuramu with jurisdiction. He also argues that the question relating to such inherent lack of jurisdiction can be raised in any proceeding, etc. That is accepted, my lord.
So one pass.
Yes, my lord. Then, my lords, para 52 is the operative part. 51, it says inherent lack of jurisdiction. That's fair, my lord. I have to point out because judgment will say something on it. And then para 52 says, in view of the power vested in this court, sorry.
So you take exception to this reasoning of the High Court?
Yes, my lord.
By referring to 15/5?
Yes, my lord.
That it was his duty also?
Yes, my lord. Either the court should have sent, my lords, in my humble submission by an administrative order. It's not only my case in my humble submission, my lords. Everything will be affected, although I am not holding brief for them. But then 15/5, even he had, my lords, the power. And it's the learned civil court versus the learned commercial court.
Now, where is the consideration of 15.5 in the judgment?
My lord, some provisions are not considered.
15.5 not touched.
Not considered.
15.3 was considered. 15.3 was considered.
What about 15.5?
That doesn't find mention, my lord. But then, my lord, I'll be able to explain from the scheme of that it's in consonance.
The act very good, but 15.5.
But ultimately, my lord, by consent, this point was argued.
Obligation. Both the parties.
Who, my lord?
Both the parties.
But then the CRP was pending. The CRP itself, we have taken a plea that these issues are pending, therefore hold on. But then they went ahead, my lords.
No, why? Is there any stay?
There was no stay. That's what the trial court says. But then the fact remains, the
therefore,
point has been taken.
You are an award debtor, you file a 37 appeal, your appeal there is no stay, and you want that till such time your appeal is decided
No,
by
in the
the
meanwhile,
court.
no, in the life, assets are being sold out.
Consider, Mr. Shuaib.
Yeah, so sure.
Consider. Yes.
So, my lord, operative part says, para 53, at my lord, page 40. The commercial court alone is competent to execute decrees which are above the specified value. The regular civil court will not have the jurisdiction to entertain such EPs with effect from 16/5/19 in the state of Andhra Pradesh. It is only the commercial court Vijayawada or Vishakhapatnam which can entertain the EPs if they are above the specified value. Now, my lords, the part which, my lords, I said I am most aggrieved. All orders passed after 16/5/19 are orders passed by a quorum non judice. They suffer from an inherent lack of jurisdiction and they are held to be per se bad in law. Pending EP shall be transferred to the commercial court Vijayawada and both parties are given liberty to start the proceedings afresh and de novo from the set. So in view of that, all four CRPs, even my CRP was allowed, saying that, yes, you are right, the order should not have been passed at all. To that extent, all four CRPs, lords, were allowed. In the meantime, lords, I will not trouble your with too many facts. On 25% deposit, they came up to the Honorable Supreme Court in view of the change in regime in 2016. The learned execution court said deposit 25%. The Honorable High Court set it aside. We have placed all those orders. The Honorable Supreme Court, Lord, said nothing doing. You must deposit 25%. It goes back to section 34 in terms of BCCI judgment. Even then, they don't, Lord, deposit 25%. And nonetheless, 34 is decided. So that's on facts, Lord, that they have not deposited a single rupee.
Well, what are the decisions?
Yes, Lord. Lord, we had handed over a compilation. What's that? Lords, to begin with, please have Sundaram Finance.
No, you will not be referring to all 31.
No. We have marked, Lords, about 13. Those also quickly we will go through.
Just indicate which are.
Lords, I'll just indicate you, Lords. What they say, I'll indicate, Lords. Sundaram Finance at serial 15.
Serial number 15, yes.
Lords.
Then?
Not directly on the point, but this Honorable Court said that a decree, Lords, the deemed decree of the award.
No, you will take us to the judgment.
Yes,
we are just only identifying.
Yes, Lord.
Which of the 31 you are going to?
Only 13. Only 13, Lords, and quickly. Please.
13 and 15.
No, only 13 number of judgments.
13 out of 31.
But very quickly, Lords.
So which are these? Just.
Serial 15, Sundaram Finance, Lords, is the first judgment.
Yes.
Lords will see, Lords, Sundaram.
No, we will see Sundaram later on. Just give us the list of 13.
I will do that, Lord. Then the second judgment we wish to cite, Lords, is serial number 18.
18 next.
Then, Lords, the serial number 3 would be serial 13, which is
13.
Honorable Chhattisgarh in our favor.
Very well.
Serial 11, Shaji Augustine is Honorable Kerala High Court in our favor. Then serial 12, Lords, again Honorable Kerala High Court is our fifth judgment.
Then,
Lords, sixth is serial 3, first page of the index. This is a contrary judgment of the Honorable Orissa High Court.
No, this is SCC.
Oh, sorry, I'm sorry, SCC. No, I'm sorry, Lords. I saw High Court of Orissa. I'm sorry. Yes, SCC, Lords. It says something else, but we'll show that, Lords. Then serial 5 is our seventh judgment, Vijay Cotton, Honorable Gujarat High Court. This is contrary. Then, Lords, Honorable Rajasthan High Court is serial 6. This is contrary, SK Finance. Then, Lord, serial 7, Delhi Chemical is what the Honorable High Court has relied upon. It's a division bench, Lord. This will be our 9th judgment. Then, Lord, serial 8 is again Honorable Gujarat High Court. It is contrary to us. This will be the 10th. Serial 9, OCI Corporation, against which SLP has been dismissed, Lord, is also contrary to us, Gujarat. And then 10, serial 10 is the classic judgment of Dulabai on section 9. Now, my lords, in none of these judgments, they are all in the facts of their case. No doubt, Honorable Gujarat and Honorable Delhi and Honorable Rajasthan, they have said that applications includes the word execution. But the fact situation was not such, my lords, that everything was set aside and de novo execution was to start. It was against different orders passed in the course of an execution. And then, lords, we've just missed one judgment, serial 26. It's an old judgment of the Honorable Andhra Pradesh High Court Division Bench of 1987 before this controversy. But nonetheless, we'll show that it said that applications does not mean to include executions. Serial 26, not P. Bhagwanulu.
Executions are independent.
26.
Serial 26, not. It's a 1987 judgment, Division Bench of the Honorable same High Court, which has passed the impugned judgment, to say that execution and applications are different.
Serial 16 and 29 are the same judgments?
Lord, serial 16 is, my lord, Dipali Biswas. 29.
Yes, that is it.
I'm sorry for this. One is an online version, one is INSA version. It appears. Please exclude 29. But not these other.
You are referring to the same judgment twice in the compilation, but you are not going to refer to it.
No, I'm not referring to other judgments because these were on merits. All the other judgments are on merits because there is a conundrum for us, my lord. What happens to the orders passed by the learned executioner?
Mr. Gupta,
Yes,
we are
sir.
short on time.
Yes, my lord.
All 13 we will not look into.
Don't, my lord.
Just show us the Supreme Court judgments.
Yes, my lord.
Other judgments we assure you we'll look into while we.
Lord, I am grateful. So, my lord, Sundaram, page 171 of the compilation.
171.
171. Lord, I must tell your lordship, not directly on this controversy, but it says that when award is passed, then the execution, my lords, can go anywhere in the country, of course, provided it has jurisdiction. But, my lords, the entire statutory scheme was seen. Please have page 182. What we wish to rely upon was that section 32 arbitration proceedings are terminated. So, thereafter, it does not remain a commercial dispute at all. Page 633 of the report, 182 of the compilation, my lord.
182.
Para 17. What has been lost sight of is section 32 of the said act. Then after section 32, lordship sees the aforesaid provision provides for arbitral proceedings to be terminated by the final arbitral award. Thus, when an award is already made, of which execution is sought, the arbitral proceedings already stand terminated on the making of the final award. Thus, it is not appreciated how section 42 of the act, which deals with the jurisdiction issue in respect of arbitral proceedings, would have any relevance. It does appear that the provisions of the said code and the said act have been mixed up. Then conclusion, lords, is para 20, page 183 of the compilation. We are thus unhesitatingly of the view that the enforcement of an award through its execution can be filed anywhere in the country where such decree can be executed, and there is no requirement for obtaining a transfer of the decree from the court, which was a precept earlier, which would have jurisdiction over the arbitral proceedings. The effect is that the view taken by the Honorable Madhya Pradesh High Court and the Honorable Himachal High Court is held to be not good in law, while views of the Honorable Delhi, Kerala and Madras, Rajasthan, Allahabad, Punjab, Haryana and Karnataka reflect the correct legal position. So, my lord, this was on termination with respect to our argument. Then, my lords, serial 18 is Charan Properties.
Page?
This is page 198 of the compilation, my lord. It follows Sundaram and in a honorable 3 judges bench combination, lord. Lordship may only mark, lords, para 40, where it reiterates Sundaram, and I will only read, lords, just above para 41. Only para 41, in fact. Until 41, it was Sundaram. 41, in the present case, the arbitral award, in a sense, postulates the transmission of shares from the appellant to the, I'm sorry, page 2 to 6, lord. Para 41, down below. In the present case, the arbitral award, in a sense, postulates the transmission of shares from the appellant to the claimant. The only remedy available for effectuating the transmission is that which was provided in section 111 for seeking a rectification. There is therefore no merit in the challenge. And Sundaram, lords, has been reaffirmed.
Now, how is this 41 relevant for our case?
Lords, consequently, in view of the court.
41
No, I
does
read
not lay
41
down
wrong.
any law.
No, it's just above 41. I'm sorry.
Bottom of 40.
Yeah. And that Sundaram Finance, Lords, I have read, Lords, the only purpose is this Sundaram Finance has been reiterated, Lords.
Well, just above 40.
Above 41, yes.
That is the.
Yes.
Now, Lords, please have serial 13 Southeastern Coalfields, page 160 of the compilation. It's a lot short order with, in our humble submission, it captures the point. Division bench, Lords, as his lordship then was. Please have, Lords, para 3.
Para 3.
Para 3 at page 160 bottom. In the case at hand, the award was passed on 26/9/2003 and thereafter appeal against the said award preferred by the present applicant has also been dismissed. At present, execution is pending before the district court in the form of an application under 36. Even if the word application is mentioned in subsection 2 of section 15, it would mean an original application and not an application for execution of the award, which is preferred after the award has been delivered. It is not disputed before us that at present, after dismissal of the applicant's appeal against the award, no further proceedings, etc. That lordship must give notes. Page 161. Para 5, be that as it may, once the award has been rendered, the proceedings at this stage have become final and an application under 36 for execution of the award cannot be treated as an original or independent application, dehors the main arbitration proceedings in which the final award has already been rendered. In our opinion, in view of the proviso to subsection 2 of 15, the execution application cannot be transferred to commercial court. Now, Honorable Kerala High Court at serial 11, Lords, page 139. Learned single judge, Lords, 2021, page 139. Please see, Lords, page 150, bottom, para 27. Lords, para 27, bottom of page 150 of the compilation.
Yes.
It says, notes, as observed earlier, the procedure for execution is not mentioned anywhere in the Commercial Courts Act and there is nothing to indicate that the jurisdiction of other courts with respect to pending execution matters stands excluded. The absence of provision regarding execution or specific exclusion of jurisdiction of other courts with respect to execution procedures and the conscious omission to amend Order 21 CPC for hastening the process of execution can only lead to the conclusion that the word application in 15(1) does not include an execution application stroke petition and the words those procedures that are not complete at the time of transfer in 15 of the Commercial Courts Act does not take in procedure relating to execution of decree stroke awards. For the aforementioned reasons, I respectfully disagree with the dictum laid down by the Honorable Gujarat High Court in Jagmohan insofar as it holds that commercial court at the district level constituted under subsection 1 of section 3 of the Commercial Courts Act would be the court competent to execute decree awards declared under 34 of the arbitrate. In the decision of the Honorable Delhi High Court in Vijay Cotton, that is also we have placed notes, is with respect to the definition of commercial dispute under section 2C of the Commercial Courts Act, as no argument was advanced by either side on the question whether the dispute falls within the meaning of commercial dispute. I am not venturing to answer that question. Then, Lords, the Honorable High Court relies on Sundaram Finance and then Lords holds accordingly. Similar is, I will not read, Lords, another learned single judge of the Honorable Kerala High Court in 2023 at page 153.
Equally elaborate reasons, slightly but equally elaborate reasons. JC was a very against I could have relied on JC. Starts at which
Yes. Now, the Honorable High Court, and I will leave, Lord, the judgments against me to be cited by my learned friend. I have placed them in the same compilation. I have made your Lordship mark that, Lords, to save time. Please have page 24. I just want to distinguish this Honorable Court's judgment, which was cited against me, Lords, and relied upon by the Honorable High Court, is page 24 of the compilation, 2023 1 SCC 549. It's called, Lords, JC Housing versus Registrar General.
Yes.
Lords, para 14 is the distinction in itself. I'll just read para 14, Lords, at page 31. Para 14 says, my lord, the question of law arising for consideration in the present appeal is whether in exercise of powers under Section 3 of the Commercial Courts Act, the state government can confer jurisdiction to hear applications, please mark, lords, under Section 9, 14 and 34 of the Arbitration and Conciliation Act 1996 upon commercial courts which are subordinate to the rank of the principal civil judge in the district, contrary to the provisions of Section 21E. Execution was not the issue here. These applications are no doubt, and they have in all states, my lords, gone to the learned commercial court. And then, my lords, para 28 and 29. At page, my lords, 36. It says, my lords, para 28, if the submission on behalf of the appellants is accepted, in that case, though with respect to other commercial disputes, the applications or appeals shall lie before the commercial courts established and constituted under Section 3 of the 2015 Act. With respect to arbitration proceedings, the applications or appeals shall lie before the principal civil court of a district. There cannot be two fora with respect to different commercial disputes. Under the circumstances, notification issued by the state of Odisha in consultation with the High Court of Odisha to confer jurisdiction upon the Court of Learned Civil Judge designated as commercial court to decide applications or appeals arising out of arbitration under the 1996 Act cannot be said to be illegal and bad in law. On the contrary, the same can be said to be absolutely in consonance with Section 3 and 10 of the 2015 Act. Second compilation.
Yes.
Now, my lords, just to conclude, this honorable court, my lords, recently, relying on 2023, has said that, my lords, if you don't raise a point, of course, my lords, jurisdiction, in my humble submission, my lords, three types: pecuniary, territorial, and subject matter. Pecuniary and territorial, it has been held, my lords, once you don't take an objection, you don't take an objection. My lords, the law was that subject matter jurisdiction, even if there is a decree upheld till this honorable court, even in execution, somebody can say that you didn't have jurisdiction to pass this order. Now, my lords, in my submission, this is slightly diluted to say that if after a long passage of time, this should not be done. Only for that purpose, we are citing these two judgments, my lords. I'll only make your lordships mark one para. Please have, my lords.
Calcutta Improvement Trust versus some Ray, R-A-Y. It could be Surajit Ray or something like that. Madam ko bolo to tunne. Justice Sabyasachi Mukherjee.
Now, my lords, in this, please see page 76 of the compilation. The issue was, my lord, civil court or the Waqf tribunal. The suit went on in the civil court. In the first appeal also. In the second appeal, first time submission came that it was only the Waqf tribunal which should have heard the issue for Lords Sajada Nashin and Mutawali. The Honorable High Court accepted that and said that the matter should be reheard by the Waqf tribunal after so many years. In those facts, please have para 31 at page 76 bottom, my lord. Thus, in view of the aforesaid discussion, we are of the view that civil court has jurisdiction to entertain the dispute involved in the present case. Therefore, the trial court has not committed any error while adjudicating the dispute. Even otherwise, it is required to be observed that at this stage, it is the contesting respondent, the original plaintiff, who filed OS 92 before the concerned civil court, in which the present petitioner filed written statement and filed his counterclaim. And after considering the evidence adduced by the parties, the trial court decided the matter in favor of the present petitioner. During the pendency of the suit before the concerned civil court, the case was transferred to the tribunal. So the said case was registered before the tribunal. Thereafter, the tribunal transferred the case to the civil court once again in the year 2002. And ultimately, as observed herein above, the concerned civil court, after considering the material, decided the issue in favor of the present petitioner. It is pertinent to observe that the order of the tribunal transferring the case to the civil court has not been challenged by the contesting respondent, and the said decision has attained finality. Further, at the relevant point of time also, the plaintiff herein did not raise the objection with regard to jurisdiction of the civil court. In the regular first appeal, herein they did not raise the issue of jurisdiction before the first appellate court also. And for the first time, the issue of jurisdiction of the civil court was raised in the second appeal. And then in para 33, lords, the Honorable Court relies on Mumtaz. Mumtaz in turn, lords, relies on Indore versus Development Authority. And in all these paras, what I have told your lordships, that lords, inherent subject matter, territorial and pecuniary. So please have page 83 bottom. This is in all fairness, I must point out. Para 33 of the cited judgment in this judgment, Lords, is at page 83 bottom. We would like to consider one more issue by drawing a distinction between institution and adjudication. Institution of a suit before a forum where an adjudication process is the same as the other, insofar as the rights and liabilities are concerned, has got no relevancy when subsequently either an act or amendment has been brought forth conferring the jurisdiction to some other forum. In other words, the issue for consideration is the forum to adjudicate. This principle is subject to the rider that it may not have an application where there is already a decree where a party has not raised the issue of jurisdiction at any point. Now, my lords, 3 jurisdictions is at page 86 top. I have said it, my lords, I will not repeat it. Lordship may only mark. And then, my lords, just to conclude, page 91 is the other judgment of Mumtaz, where, my lords, the court has said that actus curiae neminem gravabit. The duty of the court is also, my lords, to check jurisdiction, not just the parties.
Which paras of this decision?
Yes, Lord. Page 106 is para 20, where section 9 and Lord relevant judgments.
Page 106.
Yes, Lord.
Para?
Para 20.
20.
Yes, Lord. That talks about section 9. But please have page 111, para 25. It says, Lord, page 111 of the compilation, Lord. At the top is para 25. It says, Lord, having dealt with the above said principle and making it applicable to the courts in India, we are inclined to hold that any failure on the part of the court to do so would draw the legal maxim actus curiae neminem gravabit. No one shall be prejudiced by an act of court. As a consequence, in a case where a court has failed to check its jurisdiction and a plea has been raised subsequently, and that too after receiving an adverse verdict, the forum shall not be declared as the one having lack of jurisdiction, especially when there is no apparent injury otherwise to the rights conferred under a particular statute. And then para 27, Lords, at page 115 talks about Dhulabai.
Yeah.
Calcutta Improvement Trust Act.
It's also not.
Calcutta Improvement Trust Act. Overhead. अभी है तो नहीं कितना
Else,
Lords, only only page 115, para 27, Lords, bottom.
115.
115, Lords, bottom of the page, para 27. Para 27, Lords, bottom of the page.
Page?
Page 115.
115.
Of the second compilation, Lords.
Oh, second. Just see whether this judgment helps you or not.
Lord, we have taken it out. We have taken it out, Lord.
How did you know?
Lord, the mic is a giveaway. Your lordships were referring to Calcutta Improvement Trust and the honorable judge, so
you have to be very careful.
It's like council sometimes close down the mic, the speaker, perhaps your lordship may also.
No, we may be discussing something very secret and confidential that will go to you.
Lord,
we are quite loud.
An art now.
The movement we can understand.
Yes, it's big.
We could be discussing many personal things.
yes. Those we will not disclose in any case, Lord. That we have heard. Lord, 115 bottom, para 27.
So just think of this.
Yes, Lord.
You know, there are different kinds of lawyers.
Yes, Lord.
Some lawyers, evoke trust and confidence to such a level that if you say one thing, we will never ask you to open the file to show where you have pleaded it.
Yes, Lord.
But there may be mischievous lawyers.
Yes, Lord.
Right?
Yes, Lord.
Who make submissions which are not to be found in the four corners of the petition.
Yes, Lord.
Now today, suppose I tell my brother that be very careful about this lawyer. What?
He will hear it, Lord.
Huh? He can raise a point of bias. You accuse. Nowadays, anyone and everyone raises such pleas. Accuse.
Yes. During virtual hearings, we saw the honorable judges would switch off the mic while speaking to them, Lord. We saw that, Lord.
Yeah,
TV, we saw that.
The lesson for us, we learn every day, and this is a new lesson.
No, we are sorry if, Lord, we
No,
sorry, but that was only to.
For reminding us.
Actually, very thankful to you.
I'm grateful, Lord.
We didn't realize that.
Okay, this
No,
judgment help you?
Para 6 does.
Para 6, yes, it does. Lord.
Para 6, yes.
But he can't be allowed to blow hot air.
Of an award and not before. We are unable to accept this differentiation. The principle is that a party shall not be allowed to blow hot and cold simultaneously. Long participation and acquiescence in the proceeding preclude such a party from contending that the proceedings were without jurisdiction. We are grateful for your lordship's memory.
What does Russell on arbitration say?
It says, Lord. Para 7. Russell on arbitration explains the position. If the parties to the reference either agree beforehand to the method of appointment or afterwards acquiesce in the appointment made with full knowledge of all the circumstances, they will be precluded from objecting to such appointment as invalidating subsequent proceedings. Attending and taking part in the proceedings with full knowledge of the relevant fact will amount to such acquiescence. The Judicial Committee in its decision in Chowdhury Murtaza Hussain versus Masumat Bibi Bechunisa observed, on the whole, therefore, their lordship think that the appellant, having a clear knowledge of the circumstances on which he might have founded an objection to the arbitrators proceeding to make their awards, did submit to the arbitration going on, that he allowed the arbitrators to deal with the case as it stood before them, taking his chance of the decision being more or less favorable to himself, and that is too late for him, after the award has been made, and on the application to file the award, to insist on this objection to the filing of the award. Relying on the aforesaid observations, this court in N. Chelappan versus Secretary KSEB acted upon the principle that acquiescence defeated the right of the applicant at a later stage. In that case, the facts were similar. It was held by conduct that there was acquiescence. Even in a case where initial order was not passed by consent of the parties, a party by participation and acquiescence can preclude future challenges. In the grounds of appeal, no prejudice has been indicated by the appointment of the second arbitrator. This is very, very important. We are grateful to your lordship's note. We just wanted to conclude by saying what is the prejudice they have to answer. And page 115 to conclude, Lords, para 27, the second compilation. It says thus, my lord, as a principle of law, the powers of the civil court being plenary in nature, the onus lies on the party who contends that it lacks jurisdiction. However, this does not take away the duty of the civil court to check its own jurisdiction, more so when a specialized forum has come into being as a creature of a statute. Of course, there may be certain exceptions when fundamental principles governing common law, including the ones pertaining to the principle of natural justice, stand violated. To deal with the said issue, one has to take into consideration the objective behind the enactment along with the provisions contained therein under, and then dhulabai, which is section 9 CPC, my lord. Like I said, my lords, order 21 does not even find mention. My lords, the reverse would have been prejudicial to them in my humble submission. If, my lords, the learned commercial code would, my lords, cut across order 21 to adopt a different procedure, then perhaps they could have said that no, civil court only should. The entire order 21, Lords, the problems of a litigant begin in India after a decree. Lordships have held so many times. This is the... He successfully stalls my execution and then comes and says that it should have been expedited under the Commercial Courts Act. So there is no prejudice, not. It's the same learned district judge would have been designated as the learned commercial judge. Lord, in 2025, my award amount was 65.47 crores, not a single paisa paid. We are deeply obliged to your lordship.
Well, payments have been released and not a single paisa is absolutely factually incorrect.
No.
My lords,
I have filed an IA, you have not responded.
No, my lords.
So we are deciding a point of law.
Very well.
Don't be
Right.
bothered about whether payment has been made or not.
Right. And my lords, the first point, my lords, where is the prejudice, my lords? Saying that I had stalled the proceedings. 34 and 37 does not mean we are stalling the proceedings. I'm entitled, my lords, as a judgment debtor, my lords.
34, 37.
Right, very well, my lord. Your lordship.
Before the High Court.
Right.
That the additional district judge at so-and-so place, he is not the commercial court, designated commercial. And you have succeeded on this.
True, my lords.
That is stalling.
Yes, my lords. The thing.
Execution. You pursue your remedy under 37, nobody stops. But today, please answer first 15.5.
My lords, I'll come to that, my lords.
No, first 15.5.
Very well, my lords. Your lordship may kindly come.
Start with 15.5.
Very well, my lords. Lordship may kindly look at 15. My lords, I've got other points, my lords. We have to come to 3 and 6. But I'll first answer your lordship straight away.
Come to 5?
Yes. My lords, come to 15, my lord. Let us see the whole 15 as a whole.
Right.
And then, my lords, your lordship may kindly see 15.1. All suits and applications, including applications under the Arbitration and Conciliation Act, your lordship may mark that as well, relating to a commercial dispute of a specified value pending in a high court where a commercial division has been constituted, your lordship may kindly mark these words, shall be transferred to the commercial division. I'm coming down.
What is the heading of the chapter?
My lords, transfer of pending suits.
The suits would include execution.
My lord, that's what the all suits and applications, your lordship, it explains.
Justice, if you go by Justice Chinappa, it is
Right.
view. Not only every section, you have to read the chapter headings also. It's not a marginal note that,
No.
marginal note does not conform with the body.
No.
You can leave aside the marginal note. But the chapter heading is very important.
It talks about the Arbitration Act.
Suits.
Correct, my lord, but the provision specifically talks about the Arbitration Act. It very well clearly states that. My lord, your lordship may kindly mark the word shall. Your lordship got it, my lord, 15.
Shall be transferred.
Shall. Lord, it has got some meaning, kindly mark shall. Now again 2, my lord, section 15.2. All suits and applications, my lords, including applications under the Arbitration and Conciliation Act.
Yes.
Again, my lords, a reference to the Arbitration Act. Relating to a commercial dispute of a specified value pending in any civil court in any district or area in respect of which a commercial court has been constituted, again mark the words shall be transferred to the commercial court. So both the provisions talk about there being a shall. In other words, my lords, it's a mandatory provision. Now lordship may kindly come to 15.3, which is according to me an automatic provision. Now your lordship may kindly look at 15.3. where any suit or application, including an application under the arbitration conciliation, 3 times they use specifically the act, arbitration act, and they use the word application, relating to a commercial dispute of specified value shall stand transferred to the commercial division or commercial court under subsection 1 or subsection 2. The provisions of this act shall apply to those procedures that were not complete at the time of transfer. Now, my lords, it is a automatic transfer here. There is no legislator, there is no, in fact, my lords, my most respectful submission is an interdiction of a court is also not required. Because, my lords, for the simple reason that it is a automatic transfer, my lords, I will try to place my, make good the, come to 15.5 minutes. I'm now coming to 15.5.
It is accepted.
Now 15.5 minutes. Now come to 15.5 minutes. That's the problem we are facing. 15.5, your lordship may kindly see, in the event that such our application is not transferred, that is any of the 3 things happen, despite the automatic transfer. Yes.
It doesn't happen.
It does not happen. Then what happens? In the manner specified in subsection 1, subsection 2 or subsection 3, the commercial appellate division of the High Court may. Now your lordship may kindly mark the word may. My lords, here my lords, as far as the volition of the parties are concerned, the word may is used. Whereas in all the other 3 provisions, the word shall is used. Therefore, my lords, if 2 different words may and shall are used in the same provision, my lords, may should be read as may, shall should be read as shall.
Under 15, 1, 2, 3,
right.
Who transfers?
My lords, the A15.3 court transfers. It
transfers?
My lords, or it automatically gets transferred.
Automatically. So it's the court that transfers.
Right.
It's an administrative function.
This may not be so, my
It's
lords,
an
because,
administrative
my lord,
function.
but then the court has to decide the
Saying
jurisdiction.
shall,
Yes.
so all suits and applications shall stand transferred.
True.
It does not require the judicial order of the court.
My lords, it may be required. I'll tell you, lords, why, my lord, because it talks about territorial transfer as far in 5.
If it is not transferred, there is a duty, there is a automatic transfer if all these conditions under 15, 1, 2 and 3 are fulfilled. Suppose
right.
It is not transferred.
Right.
And a person like you who thinks that yes, it should have been transferred, but why has the court not transferred it? So you make an application.
May.
You make an application.
I may make an application. Well,
Wait. You are given the
option,
enabling provision.
Right.
So it enables a party. A party feels that why should it be heard by the civil court? This is covered by the Commercial Courts Act.
True.
So it should have been automatically transferred.
True.
But for some reason or other, it is not transferred. So this enabling provision gives you the authority to apply before the court.
It's an entitlement, my lords, but
Entitlement. Now this may means the court may hear the registry also why it has not transferred.
not necessarily.
Registry may give an explanation. That is why this decision is left to the court.
Well, let us read the entire.
No. Please. Entirety is this. What is the object? What is the object of 15.5?
Well, I'll straight away answer.
By a slip of the administration, any suit, any application which could have automatically gone to the commercial court under 1, 2 or 3 has not gone. But it may be so that the registry may have some objection that for this reason it should not go.
No, it's not.
So when you make an application, the court applies its mind. Court may accept your version that all boxes are ticked in my favor. It should go. It could also happen that the registry points out something that it is for this reason we have not sent. So therefore, even if the registry raises a justified objection, the statute will say that shall, the court shall. That is why it's may.
Well, that's the may is for a different reason. The may is different because 15.5 talks about territorial jurisdiction.
Why didn't you file an application? Tell us.
My lords, the fact is.
Why didn't you file it? Automatically it did not go.
My lords, answering your lordship's point, my lords, let's look at 15.5, my lords. Let me complete that argument, my lords. I'll answer that point, my lords, because that could be important. Your lordship may kindly look at 5, my lords.
Yes.
I will read from. Shall I read that provision again, my lords? In its entirety, just 15.5, my lords. Please bear with me. In the event that such suit or application is not transferred in the manner specified in subsection 1, subsection 2, or subsection 3, the Commercial Appellate Division of the High Court may, on the application of any of the parties to the suit, withdraw such suit or application from the court before which it is pending and transfer the same for trial or disposal to the Commercial Division or Commercial Court, as the case may be, having territorial jurisdiction over such suit, and such order of transfer shall be binding, final and binding. Now, my lords, as far as this provision is concerned, it comes into application only when there is a dispute with regard to the territorial jurisdiction, not with regard to the subject matter jurisdiction, lords. In which case, it's not merely an administrative order, because 15.5 requires a judicial determination as to whether
15.5 leaves it open about the subject matter. If you see, it will be transferred to the court having territorial jurisdiction.
Yes, therefore only territorial jurisdiction would, therefore judicial determination is required. Subject-wide jurisdiction, that's why may is used.
So therefore, let us assume, as in this present case, the concerned judge did not have the jurisdiction because he was not the designated.
To start with.
Right. Now, if you had made an application under 15.5.
Not, I have not made.
If you had.
Right.
Listen.
Right.
You don't waste words.
Right, right.
If you had made an application that this is a case which is covered by 1, 2, and 3, and therefore registry should have automatically transferred it. It has not been transferred. So please transfer. Mr. Gupta raises an objection that no, it should not be transferred for XYZ reason. Then you are asserting that it should be transferred. He is asserting it should not be transferred. Leaving aside the registry's view. Now, if the court is in your favor, right? There are 2 designated commercial courts.
Right.
So this matter cannot go to both courts.
One of the courts.
So this is that. Last portion is that. To which court between the 2 it will go is determined by the last.
No, that may be in the fact situation of this case.
And
but when your
transfer
lordship
the
is laying
same-
down the law,
And transfer the same for trial or disposal to the commercial division or commercial court as the case may be, having territorial jurisdiction over such suit. Why do you say that? It
then,
is
my lords,
restricted
if that is the
only to
case,
territorial jurisdiction?
my lords, then, my lords, 15.1, 2, 3 becomes OTOs then.
Of course not.
My lords, it does, my
Of
lords.
course not. Of course not.
My lords, but
1, 2, 3, you say that it is covered. He comes and says it is not covered. Now take the converse case. The court holds in his favor that yes, Mr. Gupta is right. It is not covered by 1, 2, and 3. What happens? Court may, therefore, court will refuse your prayer and court will say that the court before which the proceedings are pending, that court will proceed.
my lords, then, my lords, if the 3 sections, if my lords, at the 3 different stages of 1, 2, and 3, my lords, 1 misses, then 15.5 should not be a corrective exercise that you go back to 15.3.
Come 15.5, we have got your answer.
So,
the other points.
right. Lordship may kindly come to section 3 and come. My lords, and there is no waiver in 15.5 also, my lords. Ultimately, my lords, as far as the jurisdiction of 15.5, my lords, is concerned, then, my lords, probably, my lords, in a case, apart from, not in this case, my lords, generally, then in every case where 1, 2, 3 fails, if the remedy under 15.5 is not exercised, then 1, 2, 3 need not be followed at all. My lords, in such cases, my lords, with great respect to your lordship, if 1, 2, 3 fails, five, my lords, would not be a would not be a saving provision to cover up 1, 2, and 3 failure. That's my short submission.
Okay. When this act came,
Right.
it came with an object that commercial dispute should title. Right?
Right.
So 15.1, 2, 3, do they involve any judicial function of the court?
With great respect
As
to
you
you.
read it, shall. Arbitration. Does it involve any judicial function?
My lords, ultimately,
Read it out.
My respectful
There's
submission is,
nothing about judicial. function. It's left to the administrative side of the court. Now, if the court, a genuine case is not transferred and a party is seeking early disposal, what will he do? He is given the remedy by 15. You can approach the court. Look here, sir. Your officers are not doing it. Do it. He raises an objection. Either way it can go. This is the judicial function. And territorial jurisdiction would mean if there are multiple commercial courts, the court will have to decide which court it will be.
there is no prohibition of raising it at a later stage, my lords, apart from that. Because, my lords, if,
There is
my
no
lords,
prohibition, but today everything depends on the facts and circumstances.
true, my lord, definitely true.
Right?
My lords,
Now,
because what happens is, my lord,
when you have been given the
option to,
do it, you don't do it.
my lords,
And then after at a
they
later
could have also
stage-
raised it. my
But
lord.
what is the, they have not raised this, very good. What prevented you from doing it?
No, it was not raised.
Today, what is,
That
the
is,
court had
stars at my face, it has not been
So
raised.
therefore, Justice Sundesh's judgment is on actus curiae nemanim gravabi.
My lord, that's a different,
It was the court's duty.
my lord, but that, my
The
lord,
court
that,
has not done it. Why
Well-
should a party suffer?
my lord, but then, my lord, we can't,
And why should the party suffer? Because here it's going to an additional district judge level officer. It's not going to a munsif.
my lords, the whole provision, my lords, if 15 becomes a purely administrative act, my lords,
Which one?
the whole of section 14, my lords, if there is no judicial determination,
But not 15.5. 15.5 is judicial.
15.5 is judicial, my lords. In which case, my lords, the option is still given to me, my lords, to raise it in for in.
You did
I
not.
did not, but then 4, my lords, the waiver would not arise.
What stage?
My lord, this
You can even raise it before the Supreme Court.
my lords, no, my lords, in fact, in the High Court, it was argued by consent.
Assume
Right.
that the execution of the additional district at civil court, not the commercial court.
Right.
Right? Orders are passed. And for the first time before the Supreme Court also, you can raise this point.
No,
So,
but not in the
question
first
of
time,
law.
my lord. No, no, it's not.
It's a question of law. Chavan Paswan says you can raise it at any point, even in collateral proceedings.
My lords, I'm not going to that extent for this case.
We
Because
respect our precedents, definitely, but having regard to this 15.5, which is a special provision,
My lords,
we have to, change our mind.
my lords, in which case, my lords, it will not be an omnibus provision, my, in the sense, my lord, this is determination as far as this is concerned. My lords, as far as this was not raised here for the first time. High Court, by consent of parties, this point was raised and it was argued. So, my lords, by consent of parties, I take your lordship to the High Court judgment that this point was raised on the understanding that, my lords, once the edifice goes, then everything falls. Ultimately, no prejudice, because instead of this court, they could get this, they can move the other court, my lords. There is no prohibition as such. And now, my lords, since, my lords, your lordship since the issue has been raised with regard to 15.5, whether it is administrative or judicial, my lords, apart from that fact, my lords, that probably it may, to lay down, my lords, a law with the entire provision, my lords, because this was not argued in the High Court as well. This point, whether it's a judicial determination, it was an administrative determination, was not raised, but it was only argued on the threshold of 15.3, 10, 6 and 3. Therefore, my lords, your lordship may kindly look at the exclusivity of this act. The exclusivity of this act, my lords, is contained.
There is no point in remanding the matter to the High Court at this
No, I'm just suggesting.
Right.
My lords, I'm just.
Point may not have been raised. Well,
Since my lords fell from.
Now that it is raised before us.
But we are answering it. my lords.
Point of law.
Yes, yes, my lords. Now, your lordship may kindly look at section 3, my lords.
Yes, section 3.
Constitution of Commercial Courts. Lordship. My lords, your lordship may kindly mark the words. The state government may, after consultation with the concerned High Court by notification, constitute such number of commercial courts at district level as it may deem necessary for the purpose of exercising the jurisdiction and powers conferred on those courts under this act. Therefore, my lords, there is an exclusivity which has been created in section 3 that for exercising powers under this act, these courts have been constituted. So, therefore, that actually, my lord, debars the exclusion of another court, which, my lords, could be also found from section 21. Lordship may kindly look at section 21, my lords. Act to have overriding effect. The scheme is exclusivity. both at the stage of my lord's determination and even at the stage of execution. Lordship may kindly come to 21, my lords. Act to have overriding effect. Save as otherwise provided, the provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or any instrument having effect by virtue of any law for the time being in force other than this act. So therefore, 3, my lords, read with 21 creates an exclusivity of courts, which clearly lays down that there is an embargo on other courts to try these cases both at the trial determination, judicial determination, or even at the stage of execution. Now your lordship may read it with 6. My lords, your lordship may read it 3, 21 with 6. Jurisdiction of commercial court. The commercial court shall, again, my lords, your lordship may kindly see the word shall is used. The commercial court shall have jurisdiction to try all suits and applications. Your lordship may look at the mark the word application, because 36 of the Arbitration Act talks about applications. 36 very clearly says it's an application. The commercial court shall have jurisdiction to try all suits and applications relating to a commercial dispute of a specified value arising out of the entire territory of the state, so and so, so and so. Now, my lords, when section 6, my lords, it is a stage, my lords, each provision, my lords, has to be read, my lords, as one following the other. If, my lords, that jurisdiction has to be decided, subject matter jurisdiction has to be decided at section 6, my lords, at the section 6 level, that is the very exercise of jurisdiction at 6, my lords, then coming to, my lords, 15.5 to knock away 6, my lords, would be with great submission.
Yes, next matter first at 2 o'clock.
Very good.
Because we had stopped the council from arguing yesterday because of another fixed matter. After that, we will come back to you.
Very good.
I mentioned, Lord, item 8, your Lord.
For R2 and R3, Manoj.
Karnataka matter, your lordships had fixed at 12. There is a letter from the state government. Not we had, they have filed additional documents and affidavit today morning, and they wanted an adjournment also. So if your lordship can fix it.
Back to the petitioner, the state government, that we had
Item will not be heard by this bench.
Oh.
We'll hear it, I'll hear it with the.
Very well.
These are all pattern matter.
Then
Item
some.
is not a pattern matter.
No.
Not a pattern matter, madam. After vacation, we will.
Very well. Not just one procedural issue. Not some procedural issue. Surveys had to be not by paper publication.
That has not been done.
Item 8 will stand over.
Lord, paper publication was to be done in all SLPs, my lord. Yes. But the registry thought it's only in one SLP, so we were not given that. Would your lordship consider saying it?
If time permits, we will call on item number 8 at the end of the board.
Very well.
Very well. We'll wait.
Very well.
We'll wait.
Right.
Because we need to come back and start with the other matters.
My lords, I apologize in that item 31. I was in my legs in another court. My lords, that's that contempt matter.
We have passed it.
Yeah, my lords have passed it over. My lords, my worry is that I have a prefixed matter.
We are keeping it beyond the partial working days. We are keeping it as not.
My lords, whichever way, but my lords, I sincerely apologize. I was on my legs. In fact, I instructed my colleague she had to go ahead with the matter, but she hesitated.
Also, it was called.
My lords, I was on my legs. That's why. The other day.
We'll hear it.
So my lords
Item number 8 would be after the partial court working days.
Grateful, my lords. Much obliged.
But please inform the other side.
My lords, I will do that. No, 31. 31. My lords, I will inform the other side. I'll have my colleague.
But this order will be transcribed only upon hearing her, because she had raised vehement objection on Tuesday, saying that because of subsequent developments, the court should not decide the issue. This was the submission.
My lords, yes, she wanted to show an order which she had shown the last time. That I will argue.
Yes, provided she agrees, we are.
Yes. I'll tell.
Your lordship would be taking 5 and 8 at the end of the board.
801, I'm really sorry to inconvenience. Lordship, there was an unmuting problem in the morning. I was online. There is a date of September given because Your Lordship, I was not there. I'm really requesting for an early date. There is a stay operating against us. I'm for stay against us. We've taken monies from people. Obliged.
Yesterday, my lordship said the director has to place that advertisement. Clear a copy of the advertisement. No, iPad it is the chart.
No, of this chart,
First note, first item.
is at page 2 and 15 is at page.
Which of these are? I don't think it is in the state's chart.
Why?
Because non-teaching staff.
On compilation for non-teaching staff, like this.
It's number 15.
It's not there. Not there. Then
No, doesn't
start with this.
Yeah, Lord, yes, Lord. Now, if your lordship have my note, Lord, similarly to other matters, that note. Have you just have this chart, Lord. Yes, Lord, 15 is separate. Okay.
Yes.
Right.
So this Saifuddin is which page of your chart?
No, the name is mentioned because the
Chart. Right. Yes. Name of the non-staff provided in the petitioner's affidavit is Saifuddin. When will you start with Rajkumar?
Yes. Now, the lordship have a note of 3 pages. Lordship just have that note. Will have all the relevant documents.
Yes.
Now, my lords, my appointment, my lords, is in January 2015. January 2016. My lord. That your lordships will get, my lord. In note 1. Now, my lords, the real problem, what the state is saying, is that, my lord, the tenure of the managing committee had expired and an ad hoc committee was functioning. And therefore, these appointments, my lord, could not have been made. That seems to be the main, my lord, ground as far as these 2 persons are concerned. And, my lords, our respectful answer to that, my lord, are 2 things. My lord, this matter was pending in the High Court. And the High Court had constituted an ad hoc committee. That lordships will find that order, my lord, at page 184, at page 185, and these petitions are still pending. Consideration. Kindly have a look at, my lords, 186.
Yesterday you placed that order.
No, my lord, that was in some other, that is
Some other.
yes, my lord. Here, their lordships will recall, the High Court had said it has become defunct, the existing committee will continue.
186 of which document?
Now, this affidavit in this matter, my lord, which we have filed. No, my lord, it is along with.
What is?
Just take out. Yes, my lord. This matter was not. It's repeated in 557. There's separate affidavit, my lord.
In compliance with
Ah,
1911.
Yeah. Should have taken it out. No? Just a minute. Oh my God. Doesn't matter. You have it. You save time. The affidavit in compliance. Yes, sir. That's the one. Lordships have an elephantine memory. The page numbers are the same, but why it in the other matter also where that order was. Lordships will turn to 185, starts from page 184.
Second copy is not there.
Lord, may I hand over my copy, Lord, to Justice? I'm sorry, Lord, may have been marked. Okay.
So where is the set of arrangement?
So kindly see, my lords, 185 bottom. We make it clear the said arrangement will continue till the disposal of the appeal, as we feel so long as the dispute relating to constitution, the constitutional managing committee, and all the dispute is involved and it is not finally decided. Some independent officer must be there in the said institution to draw the government's aid from the government and disperse the same to the teaching staff and non-teaching staff. We also feel that some ad hoc arrangement should also be made for managing the day-to-day administration of the said institution until the appeal is finally decided. As such, we constitute an ad hoc managing committee with the following members for the running of the day-to-day administration of the institution till the disposal of the appeal. It is made clear that all decision-related expenses which are required, so and so. Then, my lords,
It is very clear, expenditure only.
then now kindly see the
Expenditure only. Day-to-day function.
all the decisions relating
There
to
is that the DDO appointed, right? So instead of the DDO, the ad hoc committee is being appointed for day-to-day functioning of the school
yes, no.
and to manage the expenses.
Yes, my lord. Now kindly see so the next order, my lord.
The same ad hoc arrangement is continuing.
Yes, my lord. Now kindly see, my lord.
Decided.
After admitting the appeal, we made an ad hoc arrangement for running the administration of the said institution till the disposal of the appeal. We are informed that ad hoc arrangement
was made earlier.
Yes, my lord.
Will continue.
Will continue.
Right?
Yes, my lord.
None of these orders say that you have the
My lord,
privilege of going forward with the process of appointment.
my lord, ad hoc, my lord's committee, my lord, is include. My lord, we just want to rely upon subject your lordship's, my lord, consideration. The rules, my lord, which have been framed. Just be very clear. My lord, in the rejoinder, we have, my lord, annexed, my lord, the West Bengal rules of management of recognized non-governmental madrasa. This is, my lord, 2002, which says, my lord, I'll read it and I'll place it. It's there in the rejoinder as well. That, my lord, the madrasa committee of the madrasa or any other authority empowered to make appointment to the post which such employee for the time being holds, or where such managing the ad hoc committee, as the case may be, appointed to manage the affairs of the madrasa. So, in our respectful submission,
Has the court
yes, my lord.
say that this will be the ad hoc committee contemplated by that rule?
No, I am not party, my lord, to these proceedings. My lord, just my kindly.
Advantage of this
Yes, my lord.
committee.
Yes, my lord. measure of control should be minimal and the condition appointment of staff, teaching and non-teaching, and administrative control over them. The management should have the freedom and there should not be any external controlling agency. No, this is only to shape.
Answer 1 second.
Yes, Lord.
And when we say you stop, stop.
Yes, Lord. I'll read it further. Lord. However, a rational procedure for selection.
Just the answer you just now read out.
Yes, Lord. So far as the statutory provisions regulating the facets of administration are concerned, in case of an unaided minority, this is an aided, my lord. There's no doubt.
This whatever you are saying.
Yes, my lord.
Is concerning unaided.
Yes, my lord. But I am not. No, not. I am saying.
How does it
No, not. I am not placing reliance in the context of. No, I am saying day-to-day administration. It is well settled.
Help you. It is in respect to unaided institutions. These are purely aided institutions.
No doubt about it, my lord. But what I am respectfully submitting, day-to-day administration will include, my lord, things such as appointment, etc.
From this, that day-to-day would include.
No, there is nothing excluded, my lord.
This is answering a specific question which was posed before the 11-judge bench.
No, as far as this order.
We will extend it to aided minority institutions.
Correct, my lord. I am only placing reliance on page 185, 186, my lord. There is nothing in the order which says, my lord, that the appointments are restricted. If your lordship sees that order, my lord, and the clarification which is issued on 187, 188, my lord.
Yes,
yes, my lord. Lord,
all the persons are in the same madrasa?
Same madrasa, my lord. Same madrasa. Yes, my lord.
So, we can deal with one order.
And lord, all the, my lord, as far as educational qualification is concerned, advertisement, lord's written test, all those parameters are fulfilled. There is nobody's case, my lord. But at the end of this, my lord, submission, I just place two things. Of the learned single judge, lord, before that.
To the main door, but to the back door. But public